Ladies and gentlemen of the interwebs, for tonight's show, we're going to kick it off a little early, starting with some substantive videos. Someone testifying, or at least giving an interview about the video in the Karmelo Anthony murder trial. And if you want to know what it looks like to get owned by a community note, I won't spoil the punchline until we hear what this gentleman has to say. Behold.
You seen the video, John, 2 hours. Was it clear enough, or was it fuzzy, or what?
No, it was clear. It was okay. It's clear enough where you can see the actual individual raindrops come by the cameras.
Okay.
That's how clear it is. You actually see them walking up. You see that Karmelo is already up under there. He's under there minding his business.
Dodging the rain, or
yeah, it was still raining. You know, right. I'm from Louisville, so that day we were under a tornado watch.
Right.
And we were under thunderstorm warning, and we know we had already had some light rain then, and it started raining again. Then it was over with for the day.
Okay.
So that's kind of what happened on that day, but they were at a rain delay already. And so during that time when that happened, the twins, their two buddies, and a few other kids, because there was a few kids involved with them, they were all coming from the direction of the middle school, coming walking back up.
Right.
On the video, you can see those four that actually was involved, and maybe about 3 or 4 others that was with them, skipping up, trying to catch up behind. One veered off probably toward his way to go to the coach and kind of distract him a little bit. And then the other 4 came walking together. One went in front of them, went past.
Right.
The other 4 went, and they surrounded Karmelo. You know, if you're Karmelo,
and they showed that on that video.
It's on the video.
Okay, come on.
You can see them walk.
I'm gonna say little stuff.
I'll put it this way.
Okay.
They actually tell you when you're watching the video, pay attention to this corner right here, because if you look anywhere else, you might miss different things.
Okay.
So watch those 4. Here they're 4 right there coming up.
Right.
That's exactly what they say.
Okay.
And so you have no way to be confused that it's those 4.
Okay.
So they come up, they surround them, and this immediate moment of not even a few seconds of pause, then that's when they jump. And so
they actually did jump him.
Yeah, it wasn't just no touch. It wasn't just all that moment. Yeah, it was a push. It was.
So this individual, he's not a witness, and you'll get the punchline as to who he is, or more specifically, who he isn't. Suggests that there's video that shows the group of 4 involving Austin Metcalf, his brother, surrounding Karmelo Anthony and jumping him. And the caption of, it won't do it. Hold on one second.
You seen the video, John?
Caption of this tweet. The description came from Rap House TV, and it said, we can still see this, high school staff member who claims he saw surveillance footage of the altercation between Karmelo Anthony and Austin Metcalf shares a detailed account of events leading up to the tragic incident. Yeah, I love it. The euphemisms. Getting stabbed in the chest is a tragic incident. Can you guys see the community note on this post? Readers added context they thought people might want to know. Remember, the high school staff member. The speaker is some guy, a registered sex offender. He's not a high school staff member. I don't know if it's true. It's community notes, and part of me says, if community notes wrongly label someone a sex offender, this question came up with another individual where the individual actually was not a sex offender. Can Grok be held liable for defamation? I'll always qualify with an asterisk that maybe community notes made a mistake here. But this man who just testified in great detail that it wouldn't just be exculpatory, it would be highly exculpatory evidence of the 4 gentlemen in the track meet surrounding Karmelo and jumping him. The only problem with this is that apparently from the community note, the person who says it is not an employee of the school. He's apparently a registered sex offender. And the other problem is it contradicts all the testimony that was adduced in trial on Friday and yesterday, Saturday, because some reason they're having a trial on a Saturday. So I wanted to get that out there for now. You get on the internet, the amount of disinformation and misinformation, and I won't even say malinformation. I'm listening to Gad Saad's Suicidal Empathy. I appreciate some people will disagree with Gad politically to the point where they might blind themselves to not be able to listen to the book, to which I would say you're an idiot. And if that's your basis of, I can only learn from people who I agree with, good, you'll remain ignorant for the rest of your life. But there's an element in Suicidal Empathy, and where we're talking about the propensity to convince yourself of delusions to justify what you feel virtuous in wanting to believe. And the level of disinformation going around in this trial, misinformation, which is information that is misused, disinformation. Oh, which way does it go? Disinformation is bad and is disinformation. Whatever. Disinformation. There's one of them that is information that's inaccurately represented. Other is deliberately misinformation, and then you got malinformation, which is true information, but that is bad for narratives. The amount of disinformation and misinformation in this trial is truly astonishing. You have, and it seems to be racially divided, for reasons which I still won't understand. I never racialized any of this from the get-go, despite some people on the far right side wanting to racialize this. People will racialize this incident and put out objective misinformation and disinformation to continue believing the narrative that they want, and they manufacture, if it's not out of whole cloth, at least it contradicts what we know by way of evidence. I've gotten too far ahead of ourselves. I'm going to bring in Robert Barnes. I think we're going to start with this issue because Barnes just put out a tweet where he thinks they're rigging a trial that they don't need to rig, and he's critical of what's going on in this trial. Bringing you in, Robert, sir, how goes the battle?
Good. Out in Long Beach, drinking my gin and juice in the Snoop Dogg way here because the judge said you must be here in person, Mr. Barnes, in Orange County on Friday. Show up, and the prosecution in the court says, actually, we're going to continue this for a couple more weeks. So get the joy of exploring this part of Long Beach. Interesting part, very racially diverse neighborhood here. It's Belmont Heights, something like that, not far from Belmont Shores. And Cambodia Town, highest concentration of Cambodians outside of Paris, France, and Cambodia itself here in Long Beach. So they're still counting votes. We'll probably be here a couple of years later. They'll probably still be counting votes.
No. They only need to count them for at least, to make up for another 1 percentile. It's 1.1% that the difference between Kami Raman and Spencer Pratt. Robert, before we even get into that, first of all, everybody, this is the Sunday night Viva and Barnes Law for the People. So everybody knows I'm going to share the link. Robert, I'm uploading everything now to Spotify, not through Podbean anymore. We'll see if it's more productive in terms of reach. The podcasts go up in actually video format as well on Spotify. You can check it out there. You want to support the community, you can join vivabarneslaw.locals.com. It's the best law community out there, if we do say so ourselves. And the links are all in the description if you want to support whatever. Robert, I mean, you can, I guess, give the things. Oh, yeah, sorry, go for it.
I was going to say, tonight's top topics, the most voted on was the issue with the War Powers Resolution Act and all the Israel-connected issues. We have Israel spying legal issues, the Israel new defense bill, legal, political controversy, the Lebanon war that's restarted today, where that may go, in the War Powers Resolution Act, because there's a lot of confusion about the legal process for that. Then our next top topic is SCOTUS. We got the SEC, the FCC, patents, redistricting, Seventh Amendment, forfeiture power, equity. What is equitable power in the context of federal agencies? The case that just blew up this week in terms of public opinion in a range of places, and that's BRICS. I don't even know how to say this, but BRICS Minifigs. Well, I've never heard of this thing.
It's BRICS and Minifigs, and the Minifigs is for minifigurines, and it's an aftermarket Lego buy and sell. So, yeah, BRICS and Minifigs. Minifigs is short for minifigurines.
Against the guy who's literally named Reckless Ben. Apparently his LLC here in California is Reckless Ben. We'll be breaking down that case. Are they a bunch of Lego thieves, or are these podcasters gone awry? John Bolton, let's just say I'm happy there's going to be a guilty verdict. I'm very unhappy what appears to be a sweetheart deal, but we'll get to that. Southern Poverty Law Center superseding indictment. More details about the scale and scope of what they've been up to. We got Justice Arkansas style. The case we've covered a couple of times here got some resolution about the would-be sheriff being prosecuted for killing the man who was assaulting and abusing his minor daughter.
Kidnapping his daughter. We'll get into the details.
Exactly. Is the UFC that's supposed to happen this week on Thursday, will it actually go through? There's just been a late-breaking lawsuit to try to enjoin it. Is America First Legal still a reliable legal entity for legal services? The Trump Weaponization Fund, is it DOA or does it still stand a chance? The cashier's girlfriend files another libel lawsuit. This one might have some merit, at least on paper. What the heck is this Sazan Island that's breaking up into mass public protest in Albania? Is it involving the Kushners, involving the Rothschilds, involving the Qataris, all kinds of craziness? Is it Epstein Island too? Is it a secret bunker? Almost like a hush-hush style topic. And then we got a couple of bonus topics from the and then we'll get to Karmelo Anthony here in a second. And then we got some bonus topics from the board. Well, what's going on in Massachusetts? They passed the right to audit the legislature, and the legislature's like, nah, we don't want to be audited. And then we got what's going on here in California. Is it some election fornication or just old school fortification? And then Tom Fitton, doing good work at Judicial Watch. We're using the Freedom of Information Act to get some new documents out on the would-be assassin Brandon Crooks and some oddities that show up in those documents. So that and your questions on this version of Law for the People.
And I want to bring this one up early. Bucklebrush Jones, I think it's sarcasm, but just in case it's not. Weird, the Jew derangement syndrome guy on with the Jew. It's almost like, if you think about it, he doesn't have Jew derangement syndrome. I know Bucklebrush Jones has been around for a while, and I think this is meant to be tongue-in-cheek. Robert, okay, I want to bring up your tweet. I have to bring up your tweet before we get started on Karmelo, because we haven't actually discussed this together at all. And I saw a couple of tweets from you that I thought, or at least one, that I thought was a little peculiar. And here, let me bring it up. Karmelo Anthony is on trial right now for murder of Austin Metcalf. It's in a town in Texas. I forget, McAllen, Texas, I think.
Collin County. Yeah, Collin County, a suburb, Frisco. Used to be rural, has become an exurban suburban area outside of Dallas-Fort Worth.
And the trial has gone on. Jury selection has occurred as fast as it typically occurs. And one of the issues that people were remarking upon was that there were no black jurors on the main 12 jury pool and the 6 alternates. People are fast to point out that doesn't mean that it's all white at all. There are a bunch of minorities, just not black. Other people are quick to point out that there were only 3 potential black jurors who made it through, all of whom were peremptory struck, arguably for good reasons, because they basically admitted they wouldn't be able to be.
That's not the case with these 3. That's the lie that's being circulated. So other people that were outside the jury community said that these 3 black female jurors did not say they were biased in any way, shape, or form. They did not say
they were the educators, and they said they didn't want to educate.
Correct. And people are getting those two confused. There were other black jurors who said that they could not be impartial, and they are thinking that applies to all black jurors. The 3 female jurors that are the Batson strike issues didn't say they had any bias of any kind. So that's an important distinction, because I'm seeing people hit me with this, and I'm like, no, that you guys are confusing 2 different groups. And then Sarah Uncensored is just lying her ass off. She's just a fraud.
I'm impressed with the ratio, how that even got 1.5 thousand hearts. That's kind of wild, considering your post.
Because there's a lot of ratio. I mean, there's a lot of people that want to see Karmelo Anthony convicted, and they're willing to see the rules violated and make up facts to get there. Just like the prosecution.
I'll read your tweet just for those who are listening on podcast and not watching it on video. This is your tweet. It says, the problems with Karmelo Anthony trial: 1, excluding all black jurors from the jury with a black defendant. 2, rushing the trial with 90-minute jury selection, 20-minute opening statements, Saturday trial days. 3, asking lay witnesses to opine on ultimate jury questions and legal issues. That's what we're going to get to in a second. Sarah Fields, hold on. I know she follows me. Republican precinct chair, constitutionalist. She says none of this is true.
Constitutionalist. Well, what a crock. She wouldn't know the Constitution would fell on her head.
And you say all of this is true. Why are you lying? Why is the jury picked? So I mean, let's just go through this one by one, because not only is none of it true, there are no black jurors on the jury pool. So the only question is why.
Yeah. And there was a Batson challenge brought by the defense that because the prosecution used their peremptory strikes to, I guess, about half of their peremptory strikes, to get rid of the 3 black jurors that were potentially on the jury. And we'll get into whether those Batson strikes were legitimate or not, whether the judge handled them correctly or not. But there's no disputing that, right? So for her to say, oh, I'm lying that there are no black jurors, it's undisputed there are no black jurors. That's what's like, she's just blatantly lying in such an obvious way. She could disagree with me, but she said that nothing I said was true. Everything I said is true. Nothing she is saying is true.
I would have said, you could have said you're wrong, not lying. One implies intent,
well,
but it doesn't matter.
Disagree with that as to intent or the rest. But to say all of those facts are not true and all those facts are indisputably true.
Well, that's so as far as we knew, and it admittedly it did happen quickly. When I saw journalists from NBC tweeting out witness testimony on Saturday, I'm like, oh, this must be from yesterday. Just why on earth are they having a trial on Saturday?
You got a rocket docket judge. You got that. That's what you have going on here. And the rocket docket judges, all they care about is speed of outcome. They don't care about quality of outcome. And, everything about this is a first-degree murder case. You shouldn't have 20 minutes for opening statement in a first-degree murder case. That's ridiculous. You do 20-minute opening statements in your low-level, civil trespass case. You don't do 20 minutes in a case that's life imprisonment for the person whose liberty is at stake, and for the people who feel they need or want justice. Doesn't give them justice either to have 20 minutes on the prosecution side. This is ridiculous. And then 90 minutes to pick a jury? 90 minutes in a case saturated with media coverage? In a case riddled with racial intensity on both sides? You got to be kidding me.
I'm fact checking you in real time just to double check, Robert. It's trust but verify. So the judge and yes, I'm using AI. That's as good as we're going to get now because none of us are at the trial, and this is going to be from the aggregate of the reporting. The judge, District John Roach Jr., limited both the prosecution and the defense to 20 minutes each for opening statements in the murder trial of Karmelo Anthony. That doesn't make sense.
Which is what Sarah Setzer said I lied about. She said that's not true, that it was limited to 20 minutes. She's lying. She lies about there's no black jurors. She lies about the black jurors getting struck. She lies about the 20-minute limitation opening statements. She lies about the 90-minute limitation on jury selection during voir dire. And then the next thing she lies about is she says one of my points is there's Saturday trial days. She says I'm lying about that. What fantasy world does she live in?
Well, she just
and look at all the seal clappers behind her. All the seal clappers. Woo-hoo! Yes, that's so right. Oh, yes. I mean, what is there? I get the lynching instinct that is coming out in this trial, but that's what that looks like when you have people that just blatantly lying, like Sarah is censored. Sarah Fields, a constitutionalist, wouldn't know the Constitution if it literally ran her over in the middle of the street. But there isn't meaningful dispute. All these facts are absolutely verified by any source that you look at. I'm
trying to be funny here. You're off by 15 minutes. So 1 hour, 45 minutes, not an hour and a half for jury selection, Robert. Shame on you.
Instead of 90 minutes. Yes. Okay. It was 105 minutes.
But let me ask you this, because we've talked about this at length in other cases where jury selection, the criticism is that it's always notoriously fast and you have very little ability to vet. So, I mean,
it's usually in federal trials. This is a state trial. So and this is a first degree murder charge. So even in federal trials, they usually allow more jury selection than this. They try to rush it as much as they can. But in state trials, you usually get very broad jury selection. It is not common at all for jury selection to be rushed like this. Definitely not in a first degree murder case. That is not commonplace in the state of Texas, as far as I know. Now, I know Texas is the famous documentary, The Thin Blue Line, comes from Texas, where prosecutors used to brag, a good prosecutor can convict a guilty person, but it takes a great prosecutor to convict an innocent one. That's the mindset of a lot of prosecutors in Texas historically. And so there's no reason to have Saturday trial. I mean, what it does, it tells the jury, fast, move. Not about let's get to the truth in a case where somebody's life was lost on the prosecution side and a kid's life is on the line on the defendant's side.
Let me just go back to your tweet and just read them one by one again. Excluding all black jurors from the jury with a black defendant. That is true. The only question is why. Some of them said I couldn't.
And whether or not it's constitutional or legal or not.
Okay, because some of them said I wouldn't be able to send a brother to jail. I think is what one of the excluded jurors said for bias. The three that were teachers, they said we don't want teachers on the educators on the jury.
That was their pretext. Yeah,
rushing the trial.
I'm not buying that, by the way, at all. But we'll get to that in a second.
Yeah, it's an hour and 45 minutes for jury selection. Shame, shame. 20-minute opening statement and Saturday trials. I don't mind the Saturday trial, except, you might be excluding another demographic from the jury pool. Bada bing, bada boom. But I've never heard of a trial on a Saturday.
No, it's very rare. It's very rare. And it's these rocket docket judges who send the wrong message to jurors. Very wrong message to jurors. And then the third aspect that I cite, there's also no disputing. Even Branca, who wants to see Anthony convicted, acknowledged when in his coverage of reading through the trial transcripts that this was unusual.
Well,
what they're doing is they're asking them, is this self-defense? Do you think this is self-defense, young fellow? Do you think this was murder? That's a jury question and a question of law applied to the fact. It calls for a lay opinion to which they are not qualified to answer anyway. And that has never been allowed because that gets into so there's one lawyer responded that was saying, oh no, this is allowed in Texas. Pal, this is constitutional. This isn't based on just the rules of evidence or the rules of common law rules of evidence. This is constitutionally required. It's a due process requirement. So the idea that you can just skip it, I get large parts of Texas has long ignored the Constitution in criminal cases, unfortunately and sadly. But there's no question that's what's happening. And these people are ignoring it like this is normal. I was shocked reading through it because I expected going through the trial transcripts that I was able to see published and other people covering it that, I was mostly curious about what led this kid to flip out because a lot of the caricatures around him really aren't true. He's not, I'll get to that in a second. So it's like, why did this kid just flip his lid? Mm-hmm. To which, frankly, we haven't got an answer. But I was shocked reading. I was like, hold on a second. The prosecutor's asking what? Do you think this was self-defense? Do you think, first of all, it's speculation. You're asking to speak to what somebody else's state of mind was, which they can't do anyway. The second, it's asking them a lay opinion to which they have no expertise. Third, it's asking them a question about a legal question or a law applied to fact question, which is either a judge or jury question, but never a witness opinion question. And so all of it was like, what in the heck are they doing?
Well, let me ask you this. So Robert, I presume there was an objection by the defense when they asked.
I don't know. To my knowledge, I didn't see whether there was or wasn't.
Because that you might go to the quality of counsel, but the judge, correct me if I'm wrong, Robert.
The judge should be controlled. Also, the prosecutor knows not to ask this question. Here's my question: in a case that looks pretty open and shut, we'll recount the facts and get to the legal elements here in a second. It tells me it's so political. The prosecutor is terrified of any chance of acquittal. So he's willing to rig the trial to get it. Rig who sits on the jury, rig how the trial is conducted in terms of speed over deliberation. It's called deliberation for a reason. It's not supposed to be rushed to judgment, which is what they're trying to do. And then asking questions that are completely inappropriate. And I think misframing the legal question in many respects. So you have a prosecutor these people ask, why did I mean corrupt? That's what I mean by corrupt. He knows he's doing things that are against his constitutional oath. Prosecutor's job is not to secure a conviction. Prosecutor's job is to do justice. That's it, ethically. It is not to secure a conviction. It is the only place in our adversarial legal system where the prosecutor is not supposed to be an adversary. The prosecutor's job is to do justice. The defense lawyer is supposed to be an adversary, but not the prosecutor. Their job is to get to the truth, get to what justice is. Now, they almost never value that and almost never apply that. It's mostly a crock. But that's what ethically they are mandated to do. And instead, he's asking questions that any competent prosecutor would know it is asking inadmissible evidence that are constitutional violation of the defendant's rights. And just because he might get away with it with this particular defense lawyer, this particular judge, is not an excuse. Again, this isn't an adversarial process. His job is to do justice. He's managed to make sure. I mean, I was shocked. I thought in a case with as much racial controversy around this one, they would not go out. They would go out of their way to make sure there were black jurors, not go out of their way to make sure there were none. And yet they go out of their way to make sure there were none.
So just for everybody's, also for clarity, some of the questions included, did you believe the stabbing was self-defense? To which multiple witnesses said no.
That's absolutely inappropriate. That is never a permissible question in a criminal trial in the United States of America. That is not. Was this murder? Was this tell us what you would do as a juror. That's not what you're supposed to ask any witness from the stand, period.
And another question was, allegedly, did Karmelo Anthony act in self-defense or commit murder? Witness, he committed murder. Did this look like self-defense to you? No, sir. But there were no objections, apparently, from what the summaries are. So,
yeah, at least for the summaries, I didn't see it. There's always the possibility there was, and they haven't done it, or that it was raised pre-trial and it was overruled. But so I don't know for sure. But it doesn't matter from a prosecutorial or judicial perspective. Judge's supposed to intervene and make sure this is a fair trial. That's his constitutional duty. Same with the prosecutor. So they're not advocates looking for a result. Their duty is impartiality, the protection of the defendant's rights, and truth and justice. And they're not doing that. They are rigging this trial to secure a conviction of Karmelo Anthony. And what's extraordinary to me is on the facts of the case. So to go back to the facts of the case, why this is utterly unnecessary to me, is so that you have a first-degree murder charge in Texas that requires proving that you did something that caused somebody's death, that you did it knowing and intending to cause them at least serious bodily injury. And it's second degree if you acted from sudden passion from adequate cause. And adequate cause is something that would render a mind incapable of cool reflection before taking the action. I have not yet seen, they chose to charge first-degree murder, not second degree. I haven't seen a defense yet that argues second degree instead of first degree. The difference in first degree murder is life in prison. Now, it's not capital murder. They have that in Texas. They haven't charged capital murder, so this isn't a death penalty case. Instead, it is a first degree, which is up to life in prison. On average, you usually serve 30 years and then get parole. But for someone in his age, that's basically his whole gut of his life.
Two things just to clarify, also for my own benefit. I put out a tweet that said, if convicted, Karmelo should be executed, and that was not an assessment in law because I know that he's not eligible for the death penalty in this case. I'm just listening to the witness testimony, and I think it's a slam dunk, cut and dry, and I'm open to new evidence, but we're not seeing any new evidence in terms of the defense is still self-defense. So when you say, the first degree murder versus second degree murder, did something get said that rendered him unable to think for a time being?
No.
It seems to that his defense admits he did it on purpose and not that he had clouded judgment for whatever the reason of rage. So even his defense is self-defense.
They kind of play with that because they talk about shock, surprise, felt surrounded, acted in a moment of chaos. Well, that sounds like potentially a sudden passion defense to reduce it from first degree to second degree. The main difference being second degree is a 20-year maximum sentence, usually serve 10. So
legal question. Second degree is the lesser end included in first degree, so he could still be convicted of second degree even if he's not charged for it?
Don't know. Okay. That part I don't know. But it was curious to me that there was no explicit reference to that possibility quite yet, but maybe they're planning on that as a backup plan. For self-defense, he needs to show that his actions were reasonable and that a reasonable person would fear and that he reasonably felt that it was necessary to use the force that he did to repel a use of force against him. By itself, he might have that defense. The problem becomes, was this deadly force? If it's deadly force, which is death, or which you do something that you know or intend can cause serious bodily injury, and it does cause death, then you only have self-defense if it was against the deadly use of force. So that's the general, almost universal principles around the world, whether we're talking about international law, treaties, U.S. domestic law in the civil or criminal context, military interventions, war powers resolution acts that we'll get to later, commander-in-chief constitutional authority. All of it comes back in variations of self-defense to necessity and proportionality, and some degree of objective reasonableness being a factor to that equation. So not just subject to the purely subjective intent. You have no duty to retreat in Texas. There are a bunch of presumptions that your self-defense was applicable that are not applicable here, such as someone's in your home, someone's in your car, someone's in your business, someone's attempting sexual assault or robbery. So the issue that I saw for him, and for those that don't know, what the facts that have basically come out is there was a school track event. There was a big thunderstorm, and the school and the defendant here, Karmelo Anthony, who they call Mello. I don't know whether that's because of the famed NBA player being named Melo, whether they're trying to play into that or something, or maybe that just happens to be the way it worked. Comes in. There's disputes about how he ended, and what's undisputed is that his school was unable to set up a tent. And maybe they didn't anticipate the thunderstorms. The thunderstorms go in, so he goes into another tent of another school. There has been testimony at trial that one of the other track teammates of the other school invited him into the tent and was talking to him. I was a little disturbed that the witness who disclosed that seemed to feel intimidated about everything. That tells me there's underlying problems with this case. Has been so politicized that people are not being forthcoming and honest about things. When again, they don't really need to. If you think him guilty, you have sufficient facts without trying to do all this other stuff.
And if I may, because the way you're describing it, I can steel man. Look, I think he's guilty, dead to rights, and I would have to see some very compelling evidence to not conclude that this was, if not premeditated, because Lord knows why you have a knife at a track meet where apparently you weren't necessarily even supposed to be at the track meet because the coaches, even if you were allowed to be at the track meet, you bring a knife. The steel man, what some people are going to say, there was a sudden thunder shower. People were, taking refuge under tents. He was invited in there, and they told him to leave, and he said no. And then Austin Metcalf put his hands on him.
But some of that is clearly in dispute. What exactly happened in that regard? That was the official narrative that came out. But what's come out from the trial is different. In other words, some of what's come out is that he was invited in. The one that his school didn't have a tent. That didn't come out initially. It's come out now at trial. 2, that there were thunderstorms that were taking place where the only place to go was this tent. 3rd thing that has come out at trial is that it is commonplace in Texas at track events for kids to mingle in other kids' tents. This is not illegal. It's not unlawful. It's not trespass. He hasn't been charged with that of note. So that this was on public school place where he was permitted to be at a track event on public school property. That he was invited in by another teammate is the testimony from an otherwise hostile witness, somebody that's part of the school and part of the community, the kid who died. He's there. These are the facts that are relatively undisputed. At some point, 2 twin brothers that are part of the school whose tent it was ask him to leave. How that worked is in dispute. Were they aggressive? Were they surrounding him? Was it 20 people surrounding him? Was it 2 people surrounding him? What is undisputed is that he was 50. Is that the twin brothers were about 50 to 60 pounds heavier than he was, so much bigger than he was. So the defense argument is that he was feeling intimidated, was feeling pressured. Was feeling like they were trying to bully him is what's coming out from him.
Well,
I wonder whether there's some history of him being bullied because, here's the other problem. They keep wanting to portray this kid as a thug. He had no criminal history of any kind.
Well, Robert, he's only 17 years old. I think he had some disciplinary issues.
No disciplinary issues, no gang issues, no criminal issues. Team captain of his track team, the honors student in school. Worked multiple jobs that his employers so vouched for him. They helped set up a give, send, go for him. So he doesn't fit the profile of a gang violent, he's no gang affiliations, no criminal history, no arrest history, no violence history, nothing like that. I get the impression you have a little guy. I'm also not bothered by the knife. Turns out to be like one of those little Swiss utility knives. It's a 3.5 inch.
I heard it was a 5-inch foldable. I don't know if we've seen the
yeah.
photo.
At least the way they're describing now, a 3.5 inch knife, from what I saw at trial. I'm not bothered by somebody carrying a knife with them, just like I'm not bothered by people carrying guns with them. To be honest, now I understand not everyone shares that viewpoint, but I personally don't. That doesn't concern me. Why it suddenly escalated concerns me, and I think his biggest factual issue is there isn't a credible claim that he felt his life was at risk, that he felt that he react. I mean, that's why their defense sounds more like a sudden passion defense than it does a self-defense. Because again, Now, unless you're going to argue, now, again, I haven't seen the knife or the details. There's been disputes, as you note. Some people say 5 inches. I've seen, say, 3.5 inches. When I heard 3.5 inches, I was like, that sounds like a Swiss utility knife or something, which would make a little bit more sense than another knife. But why he was carrying a knife tells me, given that he doesn't have this criminal history, and then there was one witness who said that somebody asked him about something, and when his mood seemed to be going down inside the tent, he said, I'm just a nobody. So I think something else is afoot, and it escalated just off the charts. Well, now the question is, when you take the knife out, do you not know that's deadly force? That's
and when you apply a puncture to the chest so forceful it pierces the sternum. But Robert, also the whole thing.
But they also when they pick him up, he's bawling his eyes out. He confesses right away. I mean, this is not a typical thug criminal case that people.
No, it's an idiot. It's an idiot with impulse control, and that doesn't get them off.
That could be it, or something else is. Or something else is afoot psychologically.
But hold. I just want to come back because I obviously don't have a problem with anybody carrying a knife when they don't use it to stab people. And if you have,
I'm just saying having the knife doesn't bother me.
He shouldn't have it. He shouldn't have it at school.
Escalation.
He shouldn't have it at school. He shouldn't have it on school property. And if you do,
I've mixed sentiments on that. I mean, we used to have teenage kids carry guns to school, and the schools are a lot safer when they did. That's my take. I understand that's not a universally held take.
I appreciate the steel manning. I'm not, and maybe it's because I'm stubborn and I already came to my conclusion. None of this changes anything. If he was invited under the tent because it was raining and they said get out of here, and he said no, now I'm going to stab you in the chest.
Well, the only thing that the prosecutors, I think, also being dishonest, it's suggesting that somehow him simply being in the tent and sitting there was provocation. That's not the kind of provocation that provocation is under the law. So I don't see a provocation argument here. So one of the exceptions is if you start a fight, then you don't have self-defense. The other student clearly committed assault. I mean, he committed a crime of his own accord. I don't see self-defense for that kid. He didn't establish that there was a legal right to prohibit people from being under that tent. No, there's been no testimony to that at all so far, and the state's already closed its case. So in fact, it's just the opposite. People saying that it was pretty normal for this to happen. I mean, what you have is a kid who completely lost it. Completely is my take, and I'm still curious at what caused that. Maybe we'll hear more. We've only heard from one or two defense witnesses. Now that's separate from the factual and legal question that the jury's being asked to determine.
Well, this is my issue as well. First of all, just on the issue of there was evidence, whether or not you believe it, from the witnesses of provocation from Karmelo Anthony. Touch me, see what happens. Punch me, see what happens. If you want to move me, you'll have to move me.
Yeah, I don't see that as provocation. So because that's more like an adequate. That's more like a warning. If you do this, I'm going to react. That's not provocation. Provocation is is coming up and starting a fight. It's not you sitting there, somebody coming up to you, Robert, saying you got to get out, and you're saying if you push me or touch me, you're not going to like what happens. That's a warning. That's not provocation. That's not initiation. That's a response.
I don't know. You know what? No, to me, and this is my personal opinion, it might not be legally sound. Someone says, touch me, see what happens. Touch me. And it's almost like a game like, oh, you touch their shoulder like kids.
If they come up to you, but if you go up to them and say, I'm going to grab you and throw you out, and they say, you're not going to like it, that happens, you're the one that's provoking, not them.
Now we're in a different, it depends on the fact pattern. The other
That's what I mean. My point is they initiated this. He didn't initiate this. So for provocation, the idea is that you initiated this. So I don't know why the prosecutor doesn't need to talk about that, to be honest with you. Maybe he's trying to set up some sort of other precedent they can misuse and abuse in the future. I don't know. But this isn't a provocation case. This is a deadly force case. Did he have a right to use deadly force, given that the force used against him was not deadly? So why is he talking about this provocation stuff?
Well, no, the provocation, I think, is to illustrate the premeditation from Karmelo Anthony. But you remember...
Well, premeditation here. All you need is that he intended to use force that he knew was deadly or could cause serious bodily harm. That's it. You don't need premeditation at all.
You remember with the two Texas guys fighting over the mattress, the father was found guilty because he provoked, but said, take your swing when he had a gun, take your swing. And the guy swings and then he shoots him in the head. I mean, I'm simplifying it here. That to me is what this provocation was from Karmelo Anthony. Now, it depends whether or not he was invited.
Well, what are you supposed to do then? So, I mean, here's my problem. Like, legally, you have a right to stand your ground. You have no duty to retreat. Do you stay silent or do you warn them? To me, I would prefer somebody warn somebody legally. We want to prefer somebody to warn somebody that they will escalate dramatically if you take certain action than to keep their mouth shut.
Well, ironically enough, if he had said, if you touch me, I will stab you in the heart, he would have been arrested and convicted of uttering a threat. So, I mean, the whole point is he couldn't threaten to do what he did in self-defense because it would have been a crime on its own, which is the evidence that it's a crime. And the issue here, like if he had said, touch me, I'll stab you in the heart, that's going to be, I would guarantee you that's criminal threats.
I mean, maybe it is, but I would much prefer, it depends on the circumstances. The person saying, I will fear, I'm in such bad, I will respond in this way. I want them to let me know what they will say. And I don't think the law's goal is to say, no, stay silent at what you're feeling or thinking. That's not what the provocation is all about. It's who initiates the whole thing. It's not in response along the way. And here, the victim initiated this. So that's why provocation is inapplicable here. What the sole focus should be on whether his use of, did he know he was using deadly force? And did he have a reasonable basis to believe deadly force was about to be used against him? Because that's what I don't understand is why is the prosecution trying to prove something it doesn't need to prove to secure conviction? And going someplace that's like, whether it's playing into a social media narrative or something else, it's unnecessary and counterproductive, in fact. Because I mean, if the jurors ultimately conclude that it is about just provocation, yes or no, then he could get acquitted. So it's a stupid strategy by the prosecutor as well. And I think part of it is they want to make the victim, appear completely innocent. This is a typical prosecutorial path, that they want to make the victim was purely innocent as driven snow, didn't do anything wrong. No, the victim committed a crime. The victim committed a crime of assault. He was physically assaulting this individual. He did not have a legal basis to do it at the time. But hey, he was just a kid. So that'd be something you get probation for. But that's how you take it out of the provocation. You say this kid flipped and stabbed a kid when all he did was get pushed. And I mean that's the story as far as I can tell. The prosecution should be telling.
I can anticipate the chat going crazy on suggesting Metcalf committed assault.
He clearly committed assault.
No, I'd say at worst.
How did he not commit assault? Well, what's his self-defense? The kid's sitting there and he's feeling attacked by being sitting there? No, it's disingenuous and dishonest for people to pretend. Prosecutors do this all the time, to pretend that everybody's innocent in this. 9 times out of 10, when these kind of fights go down and somebody gets badly hurt or somebody gets killed, both actors screwed up. Somebody usually screwed up a lot worse, but both actors screwed. This kid screwed up. He went up and pushed him. He had no grounds to physically hit him. He had no grounds to do so.
That's a disputed fact. I say at worst.
How? There's been no evidence whatsoever that he had a legal right to physically remove him from that place. He's a student. I think that there's enough evidence from the testimony that he pushed him. He didn't just.
So I would say at worst, battery. At worst, if you said.
That's what I mean. Yeah. It's a small minor league battery case. The prosecutor is so obsessed with this kid's got to be perfect. He has to have made no mistakes, the victims, that he has to pretend that he was provoked into doing that. And it's like, come on. When you try to push too far, when you try to go too far, you not only open the door for potential acquittals, you also create public controversy where there doesn't need to be any. So my view is he's guilty of, he's likely to be convicted and he's likely guilty, maybe of second-degree murder if we hear more evidence as to, I'm curious why a kid with no history of violence suddenly flips. I mean, this is unusual. This is not normal. And this case has been so under the context of the racial controversies taking place and the racial disputes taking place that we haven't got an honest valuation as to what causes it. Why is he carrying the knife in the begin with when he doesn't have a history of violence and he's not connected to a gang? That tells me, why did he say, I feel like I'm a nobody? What did he say, I'm a nobody? This feels like a kid who somehow is, if you look at a lot of the school shooters, one of the most common things that's common, they've been bullied. It's another issue that society just doesn't want to deal with, doesn't want to address, is the effect of social bullying on people. And my guess is this kid has a history of being bullied and freaked out when somebody much bigger than him was challenging him. And that's why when he gets arrested, you're a hardcore gangbanger. When they get arrested, they ain't crying profusely and confessing right away and asking, is he okay? That is not your typical. This is a kid who panicked, hit the wrong button, lost his head, and which means probably something built up to this.
Well,
but is that a legal defense? It might be justification to reduce it to second-degree murder. Well, I think he should have pled out on second-degree murder grounds.
That's where I would have had a different view of Karmelo's culpability if instead of trying to demonize Metcalf, he just says, it was a moment of absolute panic and, throw yourself on the mercy of the court.
I think that's a lot of part what the defense is saying. They're saying it was chaos. He thought everyone was surrounding him, and he flipped. I would have liked more story, but how do you tell that story in 20 minutes? That's absurd to me. That's just absurd to me. That's not a serious judge. That is not that cares about constitutional trials. Now, let's go to the constitutional errors that I believe have taken place. Can you get away with short jury selection? Yes, sadly, because judges in America don't care. They would rather jurors never decide any case if it was up to them. That's why they've unconstitutionally and illicitly stripped them of so much of their power, including the controlling of sentencing, which jurors should have, not judges. So they can probably get away with that, depending on some of what the objections were pre-trial and during trial. They can get away with doing the Saturday trials. They can likely get away with rushing the jury selection process, though it depends on how detailed and probing their media inquiries were. What people, especially in the social media era, that needed to be deeply dug into. What have you seen? What have you heard? What do you feel? Describe the different circumstances. Also, one of the ways you can do this is you can do reverse racial testing. So I've done this in multiple jury trials. So for example, let's reverse it. Little white kid feels beat up, been bullied, pouring down rain, goes to a track event at a school in the projects and goes into the black kids tent. And a bunch of tough, big physical guys get up to him and they think he's going to throw him out, and he reacts by stabbing. Has anything like that ever happened? Research the Bernie Getz case. Bernie summarily executed those guys while they're on the ground. That's what Bernie did. But all the whites in New York cheered that verdict all the way home. So would people feel the same? My guess is about 80% of people on both sides would suddenly flip as to who they were sympathetic to and who they were highly critical of. Not everybody, but probably about 80% or so. And I've tested it in focus groups and other places, seen it live too often to know otherwise. That's what bothered me. Like, if I was the prosecutor in this case, when I'd focus on the facts, not make up legal defenses that don't exist, don't pretend everybody was innocent in the whole equation, get to the heartbeat and the reality of it. And we can't let people, the reason why we prosecute people like Karmelo Anthony, because we can't have people freak out and go from 1 to 10 in a heartbeat. And that's why the law is the way it is. But I would make sure that there were black jurors on that jury. That on average, 18 people in a community with about 12% African Americans, you'd expect 2 jurors on there. I would make sure of that if I was the prosecution, because I wouldn't want any suggestion or any hint that this was a racially biased juror pool against the defendant. And the fact there are other Hispanic or Asian jurors does not constitute a substitute for black jurors, not in America, with a black defendant. Instead, this prosecutor did just the opposite. This prosecutor struck. Usually you only have 6 strikes. Now, maybe he gave more strikes. I don't know the number of prosecutorial strikes they had. But he used 3 prosecutorial peremptory strikes for which you don't have to have cause on 3 black female jurors. And his excuse was, well, they're teachers. Now, there's another teacher that's on the jury and was like, well, but they're not high school students. Having been through this is hogwash. This is pretext, tattooed all over it. If those 3 had been white, they'd be on the jury. I don't have any doubts about that whatsoever. I've been through this way too many times, studied it way too many times. That judge let him get away with it. But that prosecutor struck them because they were black, because he didn't want any black jurors to mess up his PR moment in the Sun, because he doesn't see in the victim a human being. He doesn't see in the perpetrator, the admitted perpetrator, the defendant, a human being. He sees a PR opportunity for political advancement. And I've been through this too many times, and too much of his trial is riddled with this. He should have been arguing against short opening statements, arguing against short jury selections, arguing against Saturday trials, because he knows of how that motivates a jury to think about rushing to the outcome, not deliberation. But that's not all. He's then asking witness after witness, including teenagers, whether they think it was murder, whether they think it was self-defense, something that requires them to speculate on the state of mind that they cannot know of the defendant, that they can testify as to the facts. This happened, and this happened, and this happened, and this happened. They can't give it interpretation. They can't give their lay opinions on legal matters that are either for the judge or the jury to determine, and that are beyond their expertise anyway and anyhow, and they require them to speculate on the mind and the intent of the defendant. So I think they have a case where the defendant is likely guilty of at least second-degree murder, but they are so obsessed and afraid of losing the case, with any risk of losing it, that they're rigging it. So I am saying the judge and the prosecutor are rigging the Karmelo Anthony trial to get a verdict that they would likely have got if they wouldn't have rigged it.
I think you've pissed off a lot of people in the chat, Robert.
I'm sure I did.
Let me bring up some of the rants, and then we're going to move on, because some of them are on this. Well, some of them, many of the ones that are contemporaneous are on this issue. MK Telephone Man says, in all honesty, I doubt he tried to kill, just happened to catch to the heart. No, you stab someone in the chest, you know it's lethal or potentially lethal. It's not, stabbing in the leg and severing a femoral artery, you could argue is more of an accident. Stabbing in the chest with enough force to penetrate the sternum, it's with the intent.
It's kind of like Bernie Getz putting a gun over them while they're in the corner and going.
There's a problem with your analogy in terms of a white kid going.
Those guys were clearly criminals, but he summarily executed several of those guys.
Well, but that's a material difference that might explain vigilante justice. Cultivated Mind says, so you can stab someone if you're not invited inside. Who cares if he is a thug or not? Don't stab people. MK Telephone Man.
I don't disagree with you at all in that regard. My point is that if you want that to become the message of the jury, of the trial, don't frame it as everybody's innocent inside the tent. Don't frame it, don't rig the jury pool so that there's no black jurors in the jury pool, and don't ask inappropriate, unconstitutional questions of witnesses to opine in place of the jury to tell them. Basically, everybody, the prosecutor, the judge, and the local community are saying, lynch him, lynch him, lynch him, lynch him, because they've got so mad about this. And I think that's not how we handle trials in America for that precise reason.
MK Telephone Man says, I'm born in Illinois, now retired in Vegas. I am okay with life in prison, against capital punishment. DNA evidence can't bring back the dead. Yeah, if they're innocent, the problem here is that all the material elements of fact are admitted. The only question is whether or not it was bona fide self-defense, which I'm not yet convinced there's any chance in hell it was. But Randy Edwards says, for me, Anthony case is one of intent with premeditation, and focusing on the facts would bring a rational juror to that conclusion. Defendant brought a knife to attract me and then whipped it out and stabbed someone in the chest when he felt that.
Now, I don't like focusing too much on that, because that's discouraging people from self-defense, including 17-year-olds. What are you doing with that gun? What are you doing with that? You're waiting to kill somebody, aren't you?
Well, first of all, if he had, you'll never sell me on that. If someone's got a gun and they're going to use it, first of all, before you summarily execute someone who might even be committing battery, then the intent is whether or not there was any realistic apprehension of life and limb here, and there wasn't. I mean, it's a pretextual fabrication after the crime. And if the kid had said, I just flipped out, instead of trying to demonize the dead kid that he stabbed to death, he was a big man. Well, Karmelo's strong enough.
No, I disagree entirely. Let's step back for this. He's not demonizing them. They're explaining why he felt that way. At the scene, the kid didn't do that at all. The kid started crying, confessed, and asked, is he okay? So does anybody think he brought the knife as premeditation? He went there to murder somebody? That's what I don't like. The suggestion is, are you armed? You're out to murder people. You're dangerous. You're scary. If you ever use your weapon, you must have premeditated. That is an attack on the Second Amendment to the U.S. Constitution. That's what I don't like. I do not care for that one iota. It's fine now. And what the defense lawyer is doing at trial is trying to explain why he felt his client felt the way he felt. That there was a big size gap between these people. That these people were acting aggressive to him. That for him it came out of the blue because he had been invited into the tent. So he's explained. That's the defense lawyer just doing his job. The kid has never done that. And pretending this kid was perfect and innocent and was fairy it's not the case. The kid who's dead decided to push somebody out of a tent. He decided to do it for whatever reason. He decided to do that. Did that deserve death? Absolutely not. But let's not pretend he was perfect in this. And then that's a mistake they always make in prosecutions. If you're a prosecutor out there, tell a real story that deals with all the ups, downs, and every part of humanity in it. Don't make somebody an angel and somebody a devil, because usually the truth in these kind of cases is in between.
We're going to read, we'll read this. King of Biltong says, turn up the flavor with Peri Peri Biltong. Mild heat, big flavor, 50% protein to keep you going. Try the full Peri Peri range at biltongusa.com. Use code Barnes. If you agree with Barnes tonight, go use Barnes' code.
Or if you disagree, use Barnes because it's great Biltong. It's good for your brain, and you'll be smart enough not to knife somebody because they push you.
Two questions for Barnes. This is from Hiroshi Shinishiban. Once his prior invitation is revoked by Metcalf, which is valid invitation or demand to leave, is Metcalf's sport team not
Metcalf is not in control of that tent. He has no legal authority to be in control of that tent. That's the problem. The problem is assuming Metcalf has any authority at all. He's got zero authority. Zero. Zilch. Zunka. Nada. There's been no testimony that he has had any such authority. This is at a public place where a school has chosen to put up a tent. That doesn't make the tent exclusively theirs. That doesn't make it part of it. And even if it did, it doesn't make some high school student the enforcer with lawful authority over who gets to be in and out of the tent.
Moving on, Robert. Let's go to one that might unify the crowd a little more. Get away from the disagreement. John Bolton. Actually, this might unify the audience in righteous rage from what seems to be yet another deep state actor getting the deep state back massage, although it's costing him a fair bit.
Well, we wanted the unifying case, but a case that should remind people I'm consistent on certain criminal defense theories. We should transition to the Arkansas police chief case.
Aaron Spencer, the man. Okay, so for those of you who don't know the backdrop or the story to this, we've covered it. It's an amazing story of corruption, a righteous, justified killing, at least by all accounts. So justified and so corrupt are the police department that they somehow lost the dash cam footage of a man, Aaron Spencer, as he chased a 62 or 65-year-old registered sex offender who assaulted his daughter, who was 14 at the time.
Minor daughter.
Sexually assaulted her. He then got charged, and at some point after having gotten charged, which took too long in any event, old man.
And just to remind everybody, the charge included, as part of his term of bail, no contact whatsoever with the victim.
After that, he got released. He then goes, the 62-year-old sex offender who was charged for assaulting Aaron Spencer's 13 or 14-year-old daughter, goes and kidnaps her in the dead of the night. Aaron Spencer manages to tail the car. They pull off on the side of the road. Aaron Spencer comes out and says, get my daughter out of the back of the truck. There's an altercation, after which Spencer, or as a result of which, Aaron Spencer unloads his magazine into the sex offender pedophile and kills him and rescues his daughter. He then gets charged with, was it a second-degree murder, or was it it was second-degree murder? It had to be second-degree murder because it couldn't have been, there had to have been some element of passion in this. Either way, gets charged with second-degree murder, and the chat will correct me if it was manslaughter, but second-degree murder. He faces charges. The police department somehow lose the memory card that he had on his dash cam, which would have, according to Aaron Spencer, totally exonerated him for having to use lethal force to save his daughter, who was in the passenger side of the pickup truck of the sex offender that he chased down at 1 a.m. after he kidnapped her from his house. They lose it. There's a whole sub-story of corruption here, who the sex offender, the alleged now deceased sex offender was, ties to the police. We could set all that aside for a bit. Aaron Spencer then runs for, it's in Arkansas, I forget what town it is, for sheriff, and gets elected. And then
gets the GOP nomination.
He got the GOP nomination. Me scusi. And then the question becomes,
but because that's consequential, because he's trying to replace the incumbent sheriff, who's part of the prosecutorial team.
And so he wins the primaries, I guess, and there's, might be the next sheriff. He would not be able to serve as the sheriff if he's convicted of second-degree murder. And bottom line, just this week, the judge in this case, or a new judge in this case, because they had an original judge who may or may not have had some role to play in the paltry bail or bond that was issued for the sex offender who then subsequently went and kidnapped. It might have been another judge, but there was some sort of potential cover-up or corruption involved there. A new judge comes in and dismisses all the charges, and in his ruling, 19-page ruling, says the misconduct was so egregious, talking about having lost the potentially exculpatory evidence, that they're going to dismiss the charges. I looked to see, apparently they were not dismissed with prejudice, which in theory means that they could refile the charges if they so choose, but apparently based on the language of this ruling, nobody in their right mind would do that. But Aaron Spencer, a man who has gone through hell, absolute hell, from beginning to this point now, daughter gets assaulted by a guy. He kidnaps her after he gets charged in order to not avoid contacting his 14-year-old daughter, had apparently electronic images on his phone that he procured from his assault, kidnaps the daughter. He murders him. He kills him, and then gets charged with second-degree murder for having shot the man that kidnapped his daughter in the dead of night. And then, because of the corruption in who the deceased pedo was, they ran this guy through the ringer in terms of the process. So a little bit of justice at the end of the day, and God willing, he'll become the next sheriff of the town. Robert, what did I miss, and what do you have to add?
Well, just what's extraordinary in this. Now, I think this judge only woke up to the Constitution's enforceability because he woke up to it right after this individual, that the person that was on trial for his life, effectively, is the defendant, the father of the girl, is the murderer of the pederast. Is after he won the GOP nomination for sheriff. Then all of a sudden, the state court judge was like, maybe we can enforce the Constitution here in Arkansas. So what happened was there was a dash cam on the truck of the so-called victim, the pederast. And the cops found it, and they took out the card, and then they supposedly they looked at it and sent it off to the Attorney General's office for forensic processing. All of this was done inappropriately. How they took it out, how they did the chain of custody, how they examined it, how they sent it off. All of it violated their own local rules about how to do chain of custody for visual evidence of this kind. And then it went missing. It just disappeared. And you have to wonder, like the story they had was that this was summary execution revenge style. That the father pulled up, dragged him out, said, "Get out," put him on the ground, and went bam, 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 bam.
Because apparently, before the man was arrested, when the father found out that what was going on, he said, he wanted to get the guy's address and was asking police for the address. And so they used that statement that he made before. They used that against him to say this was premeditated revenge killing. And I just double checked. Okay, so the dash cam in question was in the deceased vehicle, Michael Fossler's truck, not Aaron Spencer's. Okay, I had thought it was Aaron.
And that's what's key about that is that would show everything.
Over it.
Right. Well, not only that, what could it show? They claimed it didn't show anything. That was all fuzzy and went out or whatever. But my guess is their narrative, like his narrative, is that isn't what happened. Is that he got out, told him to get out, told him to get there. The guy started attacking him, and so he defended himself with shooting. And that it wasn't a summary execution situation. He was there to rescue his daughter, not summary execute. My guess is that's what the camera footage showed. It validated his line of defense, his story, that the daughter was kidnapped, that in terms of how she was acting and reacting, that and that the individual was threatening and being physical towards him, and that you had a bifurcated reason. One, that the police and prosecutors think that they alone should determine how justice gets done, and I don't always agree with that aspect of it. From under certain circumstances, I think this is a form of self-defense at multiple levels, protecting and saving his daughter from someone who had already committed crimes against her and was threatening to do so again, and physically had them in her kidnapped custody, and was in the process of committing multiple crimes, including bail jumping and the like. Mm-hmm. But it was some of the nastiest crimes. And he said that it was also self-defense because the person because they weren't staying where they're supposed to and were threatening and were going to cause harm. And so like defense of fear of sexual assault of a minor can be grounds, like it is under Texas, I'm sure it's the same in Arkansas, grounds for self-defense, including use of lethal force. So but it's because of the corruption of the police. And then I think because of the efficacy of his campaign that the court woke up to do something about the corruption of the police. But when you lose evidence like this that's so clearly potentially exculpatory, the reasonable inference is that it was in fact exculpatory. They tend not to lose evidence that's that incriminatory.
No, I especially I think it was the prior judge that refused to come to negative inferences from the fact that they had lost that dash cam footage. I mean,
right.
It would have been determinative. Like it would. I don't know if it had audio.
Absolutely would have.
If it, from inside the vehicle as well, where you can hear what was going on between. Now that I thought it was in Aaron Spencer's truck. You would hear what happened between the daughter and the man, whatever the guy's name is.
It must have been something damning because they were so eager to get it. You know that if it helped them, they would have preserved that, gone to great lengths to make sure they preserved it. Mm-hmm. They wanted to see it right away, and they saw it didn't help them, and so time to lose it. And they're just used to getting away with it. But credit to this gentleman for not letting them get away with it.
No, it's amazing. It's actually a mild, as happy an ending as you can get to this horror story, because it's been a horror story. All things in it were a horror story, and then to prosecute the man who literally saved his daughter from a pedophile who kidnapped her in the night. It's out of a movie.
Who previously abused her before. It's not like that. There was no speculation here as to who and what this guy was up to.
Now we can move to another one. Let's say, speaking of corruption, I don't know. Let's just go to John.
Well, we're going to go self-defense. The top topic of the night was the Iran Spying Defense Lebanon War Powers Resolution Act quartet of cases. Yeah, because we can offend some more.
You haven't pissed off enough people yet, Robert. Let's go.
Yeah, exactly. We got to go at it. Go boom, boom, boom.
All right, so let's go to. You'll feel this one because it's more your wheelhouse than mine, and I'm more or less burnt out when it comes to the Iran debate, the Iran discussion. I got a message before we went live tonight and said, "Hey, Viva, just in time for your show, everything's blowing up again. No pun intended in the Middle East." So this week it was 4 Republicans and the other Democrats who voted against the War Resolutions Act, which basically. It doesn't put to an end, but it doesn't empower Trump to, I don't know what. You'll have to explain to the world and me as well what it does in terms of limiting Trump's ability to engage in kinetic hostilities over in Iran. Wait, you might be on mute. Did you just mute yourself? Hold on, something happened. No, I can't hear a thing. Let me just make sure that in the chat that everyone thinks you've gone mute as well. Barnes has been.
How about now?
There you go. Okay, now we can hear you back. Okay.
This mic suddenly went dead.
Drop it. It was good. You sound just as good now.
Okay, all right.
Hold on, Robert. Hold on a second. I know you got a sense of humor. Mute is better.
So this was the War Powers. So there's been multiple acts, and this is pursuant to the War Powers Resolution Act. So the Constitution, Article 1, Section 8, gives Congress the exclusive authority, the legislative branch of government, to declare war. Also, the exclusive power to raise armies, the exclusive power to provide for the calling of the militia. Article 2 makes the President of the United States the commander-in-chief of any armed forces that Congress has raised to declare war. The Article 1, Section 7, Clause 2 is the veto power. It says that if what Congress passes is a bill, then the bill must be presented to the president, and if he vetoes it, then they have an opportunity to override, but it requires certain things. So was this a bill? That has never been fully adjudicated, but by implication, the answer is no. So the War Powers Concurrent Resolution Act, or let me go back. So during the Vietnam War, Congress realized we need a more sophisticated procedural mechanism to enforce our constitutional authorities and the separation of powers concerning military and kinetic conflicts abroad. And in that capacity, they passed the War Powers Resolution Act. And Nixon vetoed it, and they overrode that veto. So they created a process. That process includes basically if the president, it still keeps exclusively the power that it couldn't change in any way to Congress to declare war and to raise armies. What it said was if the president, for self-defense, imminent risk of self-defense, he could engage in he could use the army and or navy or our military in kinetic conflict as long as it was in self-defense for a limited period of time. 60, if he had report within 30 days, 60 days, then withdrawal unless Congress authorizes, 90 days for a subsequent extension if Congress permitted. This requires bicameralism, but not presentment. So when a war powers concurrent resolution is passed, it does not require the president's signature. It is not subject to the presentment clause. It is not subject to the veto power. The way to think of it is, it's not a bill. An act to declare a concurrent resolution to declare war, an act to declare war under the War Powers Resolution Act and under their constitutional authority is analogous to confirming a Senate nomination in the Senate, or Senate confirming a presidential appointment through the Senate, or confirming a treaty through the Senate. That's what it's like. Or like the House impeaching or the Senate convicting. Those are not things that are bills subject to the presentment clause, subject to the veto right. Wouldn't even make sense. Can you imagine the president sends down a treaty to be authorized, the Senate doesn't do it, and he goes, I veto it, hereby declare the treaty now law. That's not part of the way the world works, or the Constitution is constructed. So here, once the House passed this concurrent resolution that said he must immediately withdraw forces there's no authorization of military force. The other thing that people have mistaken is like, well, Congress hasn't declared war since World War II. That's because they changed it to authorization of the use of military force rather than the word war. Now, some people apparently think that, Bronca doesn't think war is war, even when the president calls it a war. If you want to have that defense, have at it. It's not very constitutionally consistent, that's for sure. Nor is it what the language the President of the United States himself has used, which is to call it war about 3,000 times since it started. But it is a war under the Constitution and what that word means within the constitutional context, both if you look at what the original intent was or just common sense application to it, historically or now, whichever analysis you use. So what people argue is, what if the president just ignores it? Can he do that? He can. Would the judicial branch likely intervene? Probably not. What's the remedy for Congress? The remedy for Congress is impeachment and stripping it of monetary authority. But this concurrent resolution passed that said the president, and the Senate has already passed one of its own accord, that the president has no more authority to be in Iran and must withdraw. Now the House has voted the same way. So the House, not only have they not declared war, not only is this now outside the 90-day time frame under the War Powers Resolution Act to still be there, they've now explicitly told them to get out. But this particular concurrent resolution can go over to the Senate for a unified message to the degree that is additionally needed. The president could use it as an opportunity and a pretext to say, get out, to say, look, I'd like to go forward, but Congress has done what they've done, I don't think he will take advantage of that opportunity, but I think politically it would be advantageous to him actually to do so. But there is no veto right here, and but the most likely real remedy, because the judicial branch is not likely to intervene in ways that the president is likely to respect. Unfortunately, I think either way. But the impeachment it would be Article 1 of his impeachment if he were to go back in and use the military and kinetic force after this vote by the House and the Senate. And I saw there's a lot of people misunderstanding how the War Powers Resolution Act works, what Congress's authority is to declare war under the Constitution. And those that have doubts about it, like Bronco, why does it only also give to Congress only the power to raise armies? Right? If you read the whole document, it's pretty clear they did not want one man to get us involved in war, period. And that he had to first get approval by Congress. And you get all these misrepresentations that Jefferson and the Barbary pirates. No, he waited to get congressional authorization before he took affirmative action as well. So good.
Don't let me bring it. Bastet says Trump is our president, and you can always leave. I presume he's talking to you, not me. But I think what you're saying, Robert, and people should appreciate it. He is the president, and your argument for why Congress can approve war is to avoid having one man, even if it is the commander in chief, bring the entire country into a state of war beyond.
Our founders, our founders opposed it, and I don't change my view of the Constitution to please a politician, party, or cult of personality. I keep my views of the Constitution the same, regardless of who the president is. Just like I keep my principles of self-defense the same, regardless of who the conflict concerns. And that's not going to change one way or the other.
Can I bring this one up, Robert? Because Nate, the lawyer, just texted me and said, read my chat, and it disappeared. It scrolled by, but now I found a way to pop out the chats over on CommuTube. It's only been 10 years to just figure this out. Cross Stuff says, thank you. Nate, the lawyer, Texas recognizes imperfect self-defense where an unreasonable belief or excessive force can reduce murder to manslaughter, while perfect self-defense is a complete defense.
That's
what
true.
Do you think?
Yeah, that's true. He's right. Texas has one of the most robust self-defense. And I'm unsettled that because I get why people are bothered. Their kids go to school and they don't want their kid to die because he went to a track meet because they just didn't want somebody there who they didn't feel belonged there. I get that entirely. But at the same time, we can't scrap our belief in the self-defense or constitutional due process or impartial juries or rush to judgment and the necessity of deliberation. It's all the more reason to do it, especially when you have a case that's factually compelling. But he's right that the imperfect self-defense can lower his criminal accountability. And maybe that's what they're aiming for. I think they're going to end up arguing a second degree, that they're going to want a second degree murder instruction as well. Mm-hmm. And I think the reason why they're trying to portray it through his eyes, I don't think they plan on him testifying by their Fifth Amendment questions to the jurors. I think they're going to let the physical visuals of him being, I guess, a small guy, relatively. I mean, nothing against small people. We'll see. I just think the prosecutor and the judge have unnecessarily contaminated the trial when this is a pretty straightforward case as far as I could tell.
And to clarify, Bastet, thank you. And sorry, 1776, he says, Viva, it wasn't directed at Barnes. It was directed at people who insulted me for our president. Understood. Now, let me bring this one up here because there was I had it once upon Hiro Sanishiban, who I believe is actually in Japan, if I'm not mistaken. No, maybe not. It had something to do with Japan. I remember how, it doesn't matter. Now I'm getting canceled. That's it. I'm done. Barnes, I didn't ask in hostility. Genuine curiosity, sir. To clarify, private property set up on public space means you and your cohort must back off and not the stranger. Thank you for your insight.
The key is authority, right? So let's say why does the student have authority to exclude anyone? So this was here's another way to think of it. Everybody there is an invitee, including the kid. Everybody. So let's say you're on a public property. Somebody sticks a tent up. That doesn't magically make that private property under the tent, right? So and even if it did, that doesn't mean the person who's initiating a removal of somebody has the authority to do so. So, like, let's say you're in a grocery store and somebody thinks you don't belong there. You know, whenever you do that with the thing, people make new memes, by the way.
Oh, what's this? I'm just reading some hate, Robert, you know.
But it's funny, like you try to look in the phone and it's a picture of Bibi and Trump in a compromising position. It's like, what is that? Oh, that's what that is. But so that's my point, is that and I've at least, maybe you saw it, I didn't see any evidence that they're even arguing that at all. That they didn't present anyone that he had the authority, that this was an exclusive. And instead, the evidence has been the other way, that basically when you're invited to these track events, you can go you can go wherever a tent is. Whoever set up the tent doesn't give them exclusive control over what's underneath the tent.
And then the one above it says, Aaron Nuclear, Robert was not in the courtroom. We're going off reporting and the summaries that are available. All right. Was that it for the War Powers Act?
So, like some people that are saying the other things about, seen from the trial transcripts and whatnot, what happened was people were confusing. There were some black jurors who said they couldn't be impartial with the 3 jurors who were excluded, who were part of the Batson challenge. So the issue is the 3 jurors who were excluded because of the Batson. So a Batson challenge by the U.S. Supreme Court, and Batson, remember we covered a case, Supreme Court recently reinvigorated that. And it didn't seem to me like the trial court judge followed that through. It looked like he did the two-step again. So for those that don't know, it's similar to racial discrimination or any religious discrimination, gender discrimination, sexual harassment law. They have a threefold process. You say, look, this appears to be discriminatory in its intent. Then the other side gets to say, no, there was a non-discriminatory reason why we did it. But then you get to rebut that and say, oh, no, I think that's pretextual. I didn't see the judge go through the three-prong analysis by what the public reports I saw. He just did two steps, which is exactly what the Supreme Court said stop doing 2 weeks ago.
Well, I won't, but we won't belabor. I will not belabor any more points. Yes, there's a lot of people disagree on facts. People disagree on interpretation. But since we're pissing people off, Robert, let's go to the other surprising tribal case that's been going on. Bricks and Minifigs. The jokes write themselves, because if they haven't already gone with Bricks and Mini, another F word, for those who don't like Bricks and Minifigs.
That's funny. I had never even thought of that. Now it's going to be stuck in my head. I'm going to think it's Brooks and Mini, you know.
See, like, I'm not that type of comedian. I don't do that type of humor. But if I were, I have that type of mind. I just leave it for the Joe Rogans of the world. How familiar are you with what's going on in Bricks and Minifigs?
So I became familiar with it because people kept asking my opinion. And I was like, I don't even know what Bricks and Minifigs is. I don't even know what the heck they were talking about.
200 franchises across the country. And my kid's into Lego, but I've never even knew this entity existed. I don't know where there's one in Florida. So, I mean, I guess at this point, everybody's very familiar with what went down in Bricks and Minifigs. It's a saga that's been going on since 2023, I think, give or take, of an old man who puts his very valuable collection of Star Wars Legos on consignment at a franchise of Bricks and Minifigs in Oregon. There's a disagreement as to how much it's worth. There's a disagreement as to exactly how much is sold. There's a disagreement as to whether or not the franchise was allowed to sell the Bricks and Minifigs on consignment. The franchise was subsequently terminated by the franchisor, entered into a new franchise agreement with a new franchisee who took over the location and the assets. Unclear what assets they took over, as to whether or not they took over what was ever left of the initial collection. And the story that broke, because of a dude named Reckless Ben, although I was told it was reported somewhere else and Reckless Ben just picked up on the story, is that 83-year-old man has life savings of Lego collection stolen by a big bad franchise of Bricks and Minifigs. Bricks and Minifigs corporate goes nuclear in terms of their bad PR and how to deal with them. And then this guy named Reckless Ben, there's so many legal elements in this to go over that it's almost impossible to do as a segment on a show. But anybody who wants to go watch on Thursday, I was with Nate the lawyer and Eric Hundley. We did 2 hours on this and took a lot of shit in the chat for that as well. So Reckless Ben does a whole multiple part miniseries, an hour-and-a-half documentary about trying to get the Bricks and Minifigs collection back to the old man. He incorporates a lottery so that they can then raffle off a portion of the Bricks and Minifigs collection, so that when someone goes to Bricks and Minifigs and says, redeem my lottery, if they don't do it, it's an actual crime, not just a civil dispute. What was the other things that he did? Then, Reckless Ben says, well, we're going to have to do illegal things to get back to force Bricks and Minifigs to sue us. And so they arguably defame the owners of the franchise, the franchisor. What else did they do? They broke up they acquired an interest in the collection by paying the owner's son $10,000 for certain collections. So he received $100,000 for the collection, so they could then break up or at least go to small claims for their respective $10,000 interest. They apparently sued the wrong franchise. They said they got judgment when in reality they didn't get any good judgment. And now everybody's suing everybody. The first franchise is suing the franchisor, saying it was abusive termination. The franchisor, Bricks and Minifigs, is suing the son of the guy who owns it, Reckless Ben, everybody involved. There's questions as to whether or not Reckless Ben broke the law. Then enters the American Fork Police Department, who I think it's indisputable violated Ben's civil rights, even if he had crossed certain civil lines, potentially for defamation. And then the latest news of the week was that Bricks and Minifigs just terminated their franchise agreement with the new franchisee who took over from the old franchisee, saying, there were some mistakes. They were overwhelmed with the work that was required in the changing of the inventory. I don't know where to start with this. Just you chime in with what you think, who you think did bad things in this, who you think is right in this, and what lessons can be learned from the Bricks and Minifigs scandal.
Yeah, so the main thing I followed was the suit itself. So they brought a suit for RICO, civil harassment, civil stalking, civil trespass, multiple forms of defamation. They, like so many lawyers do, they brought a separate cause of action for civil conspiracy. For the love of good Lord, civil conspiracy is not a separate cause of action. They brought a separate cause of action for injunctive relief, not a separate cause of action. Separate cause of action for declaratory relief, not a separate cause of action. Those are separate remedies or separate means of approving liability. But so so what you would do is you would say these people committed defamation. These people committed defamation by conspiracy. These people committed defamation by aiding and abetting, whatever it may be. But that's the method of liability for the underlying tort. Civil conspiracy is not a separate tort. So that was a little bit annoying, but it is what it is. They also kept saying private civil dispute. I have no idea what in the world they mean by that. It's like somehow this supposed to be magical. Why are you talking about this private civil? First of all, you're a public business, so I don't know what do you mean by private. In civil dispute, so somehow if it's a private civil dispute, nobody's supposed to talk about it. I had no idea what they meant by that. They just kept saying it over and over again. So let's go to each claim. The RICO claim, complete crap, complete utter crap. So they're claiming reckless bend. RICO? This doesn't apply to RICO.
Well, how do you have RICO in a civil claim? I always thought RICO was purely criminal.
Oh, no. We have civil analog RICOs. I brought the first sustained RICO case against a major law firm in the history of the state of California about 20 years ago. So there's a civil analog. You have state law versions and you have the federal law version and the state law versions. And they brought them to the Utah state analog version. Some of those are enforceable in different ways. But the idea of racketeering and influencing corrupt organizations in the common everyday mind, in the colloquial everyday understanding, they think of bad people doing conspiring as equaling RICO. That's why you often get, hey, can we bring RICO here, RICO there? That isn't really what RICO is. RICO is a bunch of people or is influencing a legitimate organization for criminal purposes. So it was intended like when the mob took over a local business through extortion or used it for fraud or things like that. That's what RICO is for. RICO is not. Basically, they're saying these guys committed pranks. These guys trolled us. These guys embarrassed us publicly because they keep saying we stole Legos from a nice old man. And we would want to call this the worst thing since sliced bread. Not the best thing since sliced bread. The worst thing ever. It's just not a RICO case. They don't have an enterprise. They don't seem to even understand what enterprise is. So it isn't what they're trying to make it to be. I'm not sure whether the case should even stay in Utah State Court. It looks to me like there's complete diversity of jurisdiction. They can remove it to federal court unless I'm missing something that's in there because they throw a bunch of parties in on both sides. So maybe that's how they're trying to evade it. Then harassment. Well, and stalking and before trespass. The problem with harassment and stalking is there's First Amendment limits to those laws. This is part of the Benchoof case, them challenging in Washington, that the Washington courts have previously acknowledged but refused to enforce when the judge in his case said I couldn't even talk about the Constitution in closing argument. Is that the Constitution constrains those statutes. Otherwise, investigative journalism becomes stalking. Public James O'Keefe exposure becomes stalking, like that dimwit Matthew Timmand, or whatever that loser is, who went after James O'Keefe in Florida on. So to me, everything they're doing looks like First Amendment protected activity, even for pranks for public exposure purposes. I didn't see this as stalking or harassment outside of First Amendment protected activities. Then up next, they come up with trespass. The problem is in Utah, trespass. Well, first of all, it appears that the places these people go to originally are publicly accessible. So it's not clear to me they are trespass. There's always an issue when the owner tells somebody that now you have to leave and you can never come back, how that works if you don't get a restraining order against them when it's otherwise open to the public. But putting that aside, the liability for trespass is limited in Utah, not to emotional damages, but to damages to physical property, of which I saw no evidence being presented. Then nuisance? What the heck is that? How the heck is this a nuisance? This is just like misapplication of every law known to man. Is the bricks in suit against Reckless Ben, or these brick store owners against Reckless Ben? Because enjoyment of your property, that's when somebody puts like a data center next to you, something that the folks in Washington want. This is what part of the reason we want to give them special immunity, so they can put these data centers and make these annoying noises and screw up the water and electricity and a bunch of other things in your town. That's a nuisance. This isn't what nuisance really is supposed to mean. How did they interfere with your enjoyment of your physical property? They're conflating cases and theories of torts that really don't apply to this set of facts. So then we get the defamation. And the problem here is I don't see how they're public figures, clearly, because it's your public store that's in the public business and so forth.
Well, you think, I mean, I think maybe people would take issue with that. I mean, by having a store, you're still, I mean, you don't get to defame, or you would not be held to the higher standard if you just open an outward facing retail store.
Usually because it's considered a matter of public interest, right? So you're a public store and there's a controversy over whether you're doing things legally or not. That's different than like private defamation is typically so-and-so had an affair with so-and-so, and the person they're talking about is a purely private figure. There's no public. The better way to think of it, rather than public figure, private figure, like if you look at limited purpose public figures, that's all about, is there a public interest in this? And so there's not a public interest in a lot of stuff. There is, I would say, a public interest in this. So I think they would have to show the reckless disregard standard under the First Amendment. But either way, they keep saying that calling them thieves and stealing property, but they laid out what their basis for that is and what their factual basis for that is. And anybody listening to it would know that. So I don't see it as defamation or libel either. And I get they said a bunch of, dumb, prankish, trollish stuff. Like, hey, we're going to go break some laws and whatnot. I get that. That's, ill-advised, but but I don't see it but it's not evidence necessarily of defamation, because clearly they really think that they stole this old man's Legos. It's obvious they really think that. And then they're wrong. They really think it.
I brought up the Go F Me. They're at almost $450,000. And I brought up where they're saying I stole a family's life savings. There have been some sufficient material admissions, especially now with the latest Bricks and Minifigs press release, that whether or not it's stole or misaccounted for,
they seem to admit they got some stuff that that there's at least some credibility to the allegation. So I don't see how this is a defamation. I kept thinking there was something else. And then digging it through, I was like, no, there isn't. Now, by the way, if you ever want to read how not to draft a complaint, read the complaint against Reckless Ben. Because when judges say they don't like conclusory allegations, read this complaint. This is a classic. They libeled us. They libeled us. They libeled us. They libeled us. No, tell me the facts that constituted the libel. Don't keep saying they libeled. That's a legal conclusion. That's what judges mean by conclusory allegations. Now, sometimes they misapply that to things that are not conclusory allegations. But in this case, this is riddled. This complaint, 110 whatever page complaint it was riddled with it. It was a headache reading it. Then we get unjust enrichment. So here's the problem. You still need an underlying illegal act. So you think it's unjust that these guys are making fun of you and trolling you and pranking you to the whole world because they think you stole an old man's Legos. That doesn't make it unjust enrichment. It's not. This is unfair. There's no such word as there's not unfairness in the law.
My understanding, at least under Canadian law of unjust enrichment, is that there had to have been an expectation of some form of partnership where one person acts in a way that basically violates the expectations of the other. Like, we had something going here, and now you are basically exploiting of me and what I understood our relationship to be. Just seems like they want to criminalize. I mean, effectively what they want to do is criminalize people making content. Call it at someone's expense.
Bingo. That's exactly what's going on. So I think that claim is crap. And then they had their injunction claim, in which, could you please prior restraint judge these gentlemen's speech, which has been unconstitutional since the Pentagon Papers. Decision made crystal clear. So I think it's a crap case against Reckless Ben. I think Reckless Ben may have lived up to his name in some of the words that he chose to use to describe his own activities. But these guys seem like maybe they did steal the old man's Legos. Robert, they doth protest too much, I do believe.
what's really funny is I don't think he's cooked. I think he's gotten himself into a little bit of trouble. I think some of the things he did say, like especially you're getting a Utah judge dealing with a Utah business, and it was one of the cases that I had. It was a guy from Europe who I don't think I don't think he committed any civil law violations. But my goodness, the case was so ugly. You end up in a small French Canadian town in a small French Canadian court with a French Canadian judge and some, dirty European who is exploiting and abusing of a local, shop. You understand the animosity will make the law and not vice versa. So I think, when it comes to some things Ben has said, I see a reasonable judge, even a reasonable jury saying these are defamatory statements. You've accused him of like all sorts of terrible things. There were some elements in terms of the vandalism of hanging the banner over the banner at the franchise, whether or not they had the right to go to that premise of the property.
And there's some like little stuff like that. But a lot of it was, man, these guys are really effective at pranking us. Man, they're really good at making fun of us. Please make them stop, Judge. Please, Daddy. Please, Daddy. Big Brother's being mean. It had that feel to it. It's like, and then it appears to me they're abusing the power of the local cops and lying to the local cops on a regular basis.
That's where maybe Harmeet Dillon and the FBI might want to get involved, because it was egregious in terms of blocking out the audio, not in terms of redacting it after when they asked for the FOIA request, blocking out the audio while the body cam footage is rolling, and then saying, well, you don't get to hear what we said here because we redacted it for lawful reasons. Robert, there was over on CommuTube. Looks like we have a lawyer in the chat, or at least a student. It says that guy. I can't get over here. Oh, come on. Oh, hold on one second. What's my fat finger problem here? Okay, that guy, MT7HQ, says second year law here. How did the $10,000 transactions violate UCC statute of frauds unless a video is in writing? And is that immaterial to the loan that Ben made to his friends? So two things here, Robert, because people are saying like you can't fraudulently split a claim to get it to small claims court. What you can do, tell me if it's the same thing in the States. You can voluntarily reduce the amount of your claim too. If you could say it's 100,000, I'm only going to sue you for 10, go to small claims. You don't get to reserve the 90. No. What they did here, I don't think what they did here was illegal, because you're dealing with different collections. And so say, I'll buy that collection for 10,000. I'll buy this one. And I don't think they did anything wrong there. Where I think that they did something wrong. Oh, sorry. Yes. People are going to argue about the interest that the owner even has, because Reckless Ben bought out the claim. He bought the interest in the claim from Brian, the son of the owner. He said, here's $100,000. We own your claim. We're going to now take it to small claims court because it's our interest. We've acquired it through purchase. Now I don't think there's anything to be made whole of for the owners of the Legos, because they've gotten their full, maybe even more. They got $100,000 from all of Reckless Ben's friends who bought out their interest. They allegedly got $100,000, or give or take, from the old franchise for what was sold. So I don't think Ben's dad even has a pecuniary interest in the Lego collection anymore. It's going to be up to Ben to either get it back or try to get some successful small claims.
Well, that gives us a natural transition to the SCOTUS cases this week. And the first one up, when is unjust enrichment? Unjust enrichment. The SEC was up, and they thought it was the question was the SEC was ordering forfeiture of monies that somebody made on a deal that violated SEC law, and they were ordering those monies paid to investors, even though the investors didn't lose money, but the investors' legal interest was violated by the defendants. And they brought back the old principle of equity, which says you can have unjust enrichment even without any economic harm to the victim. The victim has to have a legal interest that was violated. But the point of unjust enrichment is to prohibit somebody from gaining from breaking the law, and gives that money not to restore the other side, but as a kind of punishment and prohibition of rewarding bad behavior to the person whose legal interest was violated. So they said the SEC can order forfeiture that is only has to be tied to the law that was violated, doesn't have to be tied to any actual amount of victim compensation injury. Which reminded me, let's say, I don't know, you're a criminal unregistered lobbyist, in Washington, D.C., maybe named, I don't know, Mike Davis, and you've been lining your pockets to the millions of dollars while libeling a whole bunch of people, exposing your criminality, you might be on the hook for unjust enrichment to that money, even if you didn't cause the other party that amount. You might keep that in mind, Mikey boy.
Let me ask you this. These are the criteria under Quebec law, and I presume they're the same roughly. It's enrichment, one party makes money. Impoverishment, the other one either doesn't get a benefit or gets impoverished. Correlation, the impoverishment must be the direct cause of the other person's enrichment. And absence of justification, that there was no valid legal reason or contractual obligation. These have got to be pretty much the standard across America definitions, or at least the criteria for unjust enrichment, give or take.
Yeah, and SCOTUS just reminded what that is under English common law, which is borrowed, I think, in part in Canada, and is heavily influenced here in the U.S.
Yeah, in Canada, it's common law in every other province other than Quebec. Quebec is modified
by the Napoleonic Code, right? Code.
But even like many of the principles abide by the same principles of law.
Oh, now.
Okay, yeah, go for it.
Yeah. The next up we had, when is a fine not a fine? The Seventh Amendment to the U.S. Constitution requires jury trial. Supreme Court determined that 3 years ago in the Jareski case concerning the SEC. Here, the Federal Communications Commission issued big fines to some big phone companies. They paid the fine and sued. And they said this fine was issued without a jury trial, and that violates our Seventh Amendment rights. Goes up to the Supreme Court, and they point out the FCC has a unique process. Its fines are not immediately enforceable. That, in fact, in order for its fines to be collectible as monetary judgments, requires the government to sue and go to a jury trial where there's a de novo trial heard before it can ever be collected. So, unfortunately for all these big phone companies, they're out of luck because they already paid the bill, thinking that they could pay the bill and sue for a refund, when what they should have done was wait until they were sued in federal court, then demanded a jury trial, and go through that process. So the Supreme Court ruled that, in fact, in this instance, a fine did not violate the Seventh Amendment because it wasn't really a fine at all.
Someone says, is that one of Viva's crippled dogs? No, that's the retarded dog. the special dog.
Mentally crippled.
I'm reluctant to pick him up because it's going to make Manny jealous. The kid just slipped both dogs in my office. It's only a matter of time before someone does something or starts fighting. What else is coming out of SCOTUS?
We have Patton's case. So we're waiting on all the big cases. I don't even know if they've announced another opinion day. Obviously, there's 20 cases waiting, so there's still more. Now, this is about interference with patents, and it's been a common problem where they've been trying to extend and expand the interference law to apply to things it's not supposed to. So in the generic medication context, there's all kinds of federal law that allows generics to compete with patented medications for a range of good cause and reasons, but there's careful ways they have to do it. And some doctors were interpreting the way in which the generic drug was being marketed in ways that did infringe on the patent. And so they were suing, saying, look, doctors are getting confused. Supreme Court said that doesn't matter. You need to have active infringement is not negligent infringement. It means deliberate, intentional infringement. It means aiding and abetting kind of liability. And that cannot be based on mere omission or negligence. So it said that, in fact, the generics way they were competing was just fine, which was a major loss to the big pharmaceutical companies, and cleared that active inducement, like aiding and abetting, means affirmative action, not negligent action or the failure to take action. And then the last case was, as predicted, the Supreme Court reversed the 3 district court judges sitting on the special panel in Alabama, who said that they were quite sure that Alabama racially discriminated because they didn't take those courts' advice that they had to have 2 racial minority districts, not that they were ever concerned with race at all, according to the same court. And I was like, that contradiction doesn't really hold up. And the Supreme Court made the exact same point. So Alabama is now allowed to use its 2023 map, which only has 1 majority minority district rather than 2. And it's good they shut that down quickly because other states would have gone haywire with it. So racial redistricting appears to be finally dead in America.
There are a few subjects in law that just shut my brain off faster than redistricting.
Redistricting.
It's so damn boring. But Robert, I was going to bring up something because when you said Mike Davis, I know nothing of Mike Davis as a person. He did retweet one of my tweets this week, but it was one, I forget what it was. Ooh, I was calling out somebody. It was such a massive ratio. I forget what it was. But set that aside, Robert. This will be the segue because Mike Davis, had some big things to say about what's going to happen to the deep state. And this is what Fox News was reporting Mike Davis had to say.
This might have nothing to do with classified documents or about classified intelligence that Bolton printed in his book. Trump Justice Insider Mike Davis says Democrats, rhinos, and reporters who think this raid on John Bolton is about his book will be very embarrassed when the search warrant becomes public. Primetime's hearing Bolton was making a lot of money from overseas and may have been trafficking in intelligence. That wouldn't be putting America first. Constitutional scholar Jonathan Turley, who we just heard from, says Bolton could be looking at up to 20 years in prison. So Bolton should take his own advice and take a big, beautiful, deep breath.
I think it's important that everybody take a deep breath here. This is a very serious matter, and it would be better if we could let the legal process play out.
Robert, it seems the legal process has played out when it... How'd you get so small? When it came to... I keep wanting to say Michael Bolton. John Bolton was charged
that's
with...
Office Space, right? Remember Office Space? His name is Michael Bolton, and he hates everybody comparing him to Michael Bolton.
I know of that joke. If you could believe, I may have seen 2 episodes of Office Space in my entire life.
This is the movie Office Space, but by Beavis and Butthead director Mike Judge.
When they beat up the photocopy machine?
Yes.
Michael Bolton. Oh, my goodness. Okay, fine. That I have seen. I need to refresh my memory. John Bolton was facing a number of charges. It was retention of classified information, disclosure of classified information. What else? Leaking it. He published it in his book. And he was facing upwards of 20 years in jail. I fact-checked myself, and I'm not sure if I fact-checked myself properly. It seems that he struck a plea deal or agreed to a plea deal pursuant to which he's going to pay $2.25 million by way of fine, which oddly enough is exactly what the advance, roughly exactly what the advance on his book was. I think his book advance was $2 million. Can you imagine? He gets $2 million advance for his book. Hypothetically, it's supposed to sell that much, so you got to sell, I don't know how many millions of copies to get that back. Doesn't matter. It's all crap. It's all money laundering. And, you have to write a damn good book to make enough money, and these guys don't write damn good books. Set that aside. Okay, fine. His advance for the book was $2 million, so he's got to pay that up. And it looks like he's going to walk. Now, I had said no jail time, where it seems that there might be a possibility for jail time if a judge has the power yet to still order that he serve some time. Is it a done deal, as in it's just the $2.25 million, or does a judge have to approve it and the judge can still decide to send him to jail for 30 days or something if the judge so decides?
For those that don't know, John Bolton is a deep state murderer with more blood on his hands than any American public official in modern history. In terms of the wars, being a psychopath, he promotes. And here's what he said about people who disclose classified secrets, even though their reasons to do so was in the constitutional aid of freedom of press and freedom of speech and to expose corruption. He said that people like Edward Snowden deserved the death penalty. He said that Julian Assange deserved the death penalty. That's what he said. He said Trump should be sent to prison for life for what he alleged was much more inconsequential breaches. This is a man who they have dead to rights, who repeatedly and routinely monetized his access to classified secrets for his self-enrichment at the expense of America's national security by sharing it with friends and family members and God knows who. And he himself has said that if somebody did something like that for reasons that were not just private private immurement, that they deserve the death penalty or life imprisonment.
Mm-hmm.
And yet what the Justice Department is going to do is they are recommending a deal where he pleads guilty to just one of the counts, so that caps his risk and exposure. The only amount of the fine he pays is the amount of profit he made of his book from this illicit, unauthorized, classified access of documents and information. that only capturing part of the monetization of this, because he's been talking to foreign governments on the routine and regular, and making millions of dollars on that as well. And it is being recommended. The Justice Department is the part of the plea deals that they will recommend to the judge no jail time at all. This is a disgrace.
Well, hold on. So, who's that? My understanding is that the prosecution might ask for some jail time, but Bolton's attorneys are asking for no jail time.
My understanding is that the nature of the deal is that the government has agreed to ask for no time.
Okay, if that's so I may have.
That's a joke. I mean, it's just a joke. Just like Kleinsmith got to walk. I mean, Trump needs to rename himself Deep State Donald. If this is taking on one of the deep state, you're going to let one of the most criminal rogue actors effectively walk with a slap on the wrist that doesn't even claw back all the money he made on this unauthorized access and sharing of information. I mean, it's just a joke of a deal.
I'm going to see if I can find who's the prosecutor in this particular prosecution.
Well, the person that's at the top that's responsible is Todd Blanche. Yeah. He had to sign off on this, and he did. And apparently, he's now being promoted to permanent. He's going to be the nominee to be the Attorney General going forward by President Trump.
What is the like? I'm just trying to even understand a corrupt rationale for doing this. John Bolton, who are his friends that are otherwise indebted to him?
The Israel lobby.
Well, now you've just pissed off everybody in the chat.
Well, that transitions in to two of the hot topics this week. The other than the War Powers Resolution Act concerning the Iran war, which is a story broke from the Defense Intelligence Agency under the Pentagon, that that raised Israel to the level of critical in terms of its espionage on high-ranking U.S. military officials, including Undersecretary of Defense Albert Colby and his deputy, who I know, known for quite a while, and I keep blanking on his last name. It's Italian. I remember that. Sorry, Mike. I remember your first name. I don't realize. Israel was illicitly spying on him. To give you an idea, the critical stage is almost never reached. That's like Cuba, China. That's like Iran. That's like our deepest perceived adversaries. So that Israel is spying on our top people, including Witkoff. Not that they really need to spy on Witkoff. He'll talk freely to people like Bibi Netanyahu and others in the Israel lobby because he's deeply embedded within that lobby, financially, politically, and otherwise. I keep wondering when, like, Kushner and some of those other people will stop following me when I keep talking about some of these topics. But hey, all right, yeah, they apparently keep doing it. So that is a serious concern, and it became a new level of concern because the National Defense Authorization Act included, I think it's Section 224, a provision to effectively allow a unique special access to Israel to be on the ground floor of all of our technology, the origination of that technology, the creation of the technology, the patenting of the technology, all of it to be integrated in. Some people misconstrued it to mean the IDF could show up in our streets enforcing like the new AI, authoritarian government. It's not like that. But what it is it gives them, basically, they no longer need to go through the president. They no longer need to go through Congress to get all the arms subsidies, all the special deals, all the military and intelligence access that they want. We've never cut a deal like this with any country in history, not even during war with an ally, not with anybody with NATO, not even during the Cold War with anybody. This is an extraordinary sharing of military technology and national security secrets. That is, how is this in the interest of doing it? At the same week it gets disclosed, they're illegally spying to a critical level on our highest-ranking national security officials.
Let me just pull up an article. From 2019. This is from Politico. Take it for what it's worth. Israel accused of planting mysterious spy devices near the White House. Daniel Littman. The U.S. government concluded within the past 2 years that Israel was most likely behind the placement of cell phone surveillance devices that were found near the White House and other sensitive locations around Washington, according to 3 former U.S. officials with knowledge of the matter. But unlike most other occasions when flagrant incidents of foreign spying have been discovered on American soil, the Trump administration did not rebuke the Israeli government, and there were no consequences for Israel's behavior, one of the former officials said. So this is back in 2019. I don't think it's really all that disputed because it's been reported in many, many places, but you can choose
for a long time.
Well, yeah, I mean, people could disregard it.
there's some speculation Lieutenant Colonel Aguilar, who was the whistleblower about what was going on in Gaza, that was on with Tucker Carlson, I think last year. He speculated that this report might have been why Amaryllis Fox and who's Robert Kennedy's daughter-in-law, and Tulsi Gabbard stepped down from the Director of National Intelligence Office, was they wanted this escalated before this bill went through Congress. And the people behind the bill, which, by the way, Bibi Netanyahu has bragged, he's the one who came up with the idea for the bill. It's interesting PR they're doing these days for the Israel lobby. I wouldn't recommend it. But so, we'll see how all that transitions. And that's all happened in the middle of Albanian protest over it was such an eclectic topic. I almost couldn't even process it all. But it's this little island off the coast of Albania, Sazan Island, kind of almost sound like Satan Island. And then you hear Ivanka Kushner's description of how they came to want to buy the island. And I was like, am I in The Great Gatsby? I mean, it felt like I was back a century ago. Sorry, go ahead.
Is the protest around her $1.6 billion project acquisition of this island to turn it? Apparently it's got tunnels and bunkers and all this wonderful stuff. I covered it. I had on Kyle Seraphin, and I hadn't seen
the Bacon Cheeseburger Nationalist organization that he's co-founder of.
There are few things on earth that are better than a bacon cheeseburger. I swear to you, last week I had a bacon cheese something for breakfast. It was delicious. But no, I hadn't actually seen the clip. And then I like Ivanka. I mean, it's nice if it were Kim Kardashian or somebody else who is not the president's daughter and not in this turmoil, economic, military. Fine, this lifestyles of the rich and famous. It was very awkward. But so she's talking about acquiring an island off, I don't know, I thought it was off Greece. And
it's in between. So it's like the Mediterranean Sea, but you go up to the Albanian Sea. And she said that she was on a friend's yacht, out. And this apparently, by the way, was during COVID. So everybody else, while Kushner's telling everybody to lock down, he's out on the yacht. And she we went for a little swim and we came across this island and we just decided to hike the island and we went all the way to the top. And it was so beautiful. We were like, we must have this island. And I was like, what am I listening to? I mean, this sounds like Rose don't know. Great Gatsby was the ultimate revenge of F. Scott Fitzgerald. It was his ex-girlfriend, the love of his life, whose parents wouldn't let him marry her because he didn't have the right pedigree. And she married this Yaley, who I didn't know until I was at Yale, that the labor history professor told me that in the teens and the 20s, they used to make fun of Yaleys as stupid rich kids. That's all they were stupid, dumb frat kids. And that's who he makes fun of, that character all the way through F. Scott. It's the guy who stole the love of his life. But that she was, causing havoc everywhere she went. It struck me as right at a Great Gatsby listening to her. And then Jared Kushner discloses whose yacht it was. And that got my attention right away. They were hanging out all the people oh, Trump is, Tom Longo, who had to retract his lies about Richard Barris this week because of getting caught lying about him. But he's out saying, Trump's 5D chess against the City of London Barnes. He's maneuvering around. The most prominent City of London banking family in the last 200 years is named Rothschild. And that's whose boat they were on. Nathaniel Rothschild's boat. It's this keeps getting more and more surreal. And then it gets to the third level of surreal, which this isn't just any island. This is one of the Soviet Union's favorite secret military islands, where they had all these special sub setups, huge military bunkers, underground tunnels.
Is the idea that this would be protected from a nuclear type conflict?
It kind of sounds like it, doesn't it? I mean, it's every little level of dystopia you get thrown in. Or maybe it's Epstein Island. We got to hide the slaves in the underground tunnels, in the bunkers. So you've got, Epstein Island Part 2, you've got Rothschilds, you've got Kushner, you got Trump, you got Ivanka Trump. And then it turns out the Qataris somehow are tied into all this. It's everybody who's in the Epstein files is somehow, represented this little mini microcosm. They're bribing the Albanian prime minister. For those that don't know, Albania, before Ukraine took it over, was the center of all human trafficking in Europe for the last 40 years. They took over that. Our great freeing of Yugoslavia by President Clinton led to Albania becoming a hotbed of not only some Islamic radicalism, but of human trafficking. Some of the craziest gangsters in the world are Albanian. in the movie Taken, where he has that great line, Liam Neeson, I got a special set of skills. It's Albanian smugglers. So you get bribery, you get human smuggling, you get human trafficking, you get secret Soviet underground bases, you've got survival of nuclear dystopia, you've got the Rothschilds, you've got the Trumps, you've got the Qataris, you get it all in one. And what happens? The local Albanian public is like, for the love of God, enough's enough. Does everything have to get stolen? Because apparently it's supposed to be a natural preserve for like the flamingos. So they're called the flamingo protests because the flamingos need this little island. And so and apparently there's now opening up investigations into whether corruption took place, whether the deal was done illegally, because they're talking about making like this special elite resort island. But it is the tale of our times. This is the Sazan Island story, and the fact that no less than Hunter Biden is busy trolling everybody about it.
Well, have we discovered if it's actually Hunter Biden behind that account, or is it a parody?
It's a blue check mark. It's really Hunter. I got to give him credit. He's good as a troll. He's like O.J. Simpson. Like, maybe he committed some crimes, maybe he didn't, but he's a good troll.
Robert, I don't even know if this is the clip.
Did the Simpsons predict this?
Yeah, no, I don't think so. This is
Nasz
the Albanian
pet.
Tot më morin mali pa tu diallo.
Ele mo det më morin moli per tu. Per toni me duhet me shkua.
What the heck? That wasn't. Anyway, I was trying to find a funny clip about this. There was a whole Albanian connection to The Simpsons. So that's interesting, Robert. I did not know that they were actually protesting this. Now, I heard that. Okay.
For the flamingos. So it was fascinating. The other topics we have this week. We'll see which ones we cover here, which ones we cover at the after party. Southern Poverty Law Center superseding indictment. UFC, will the event go forward or not? A late-breaking lawsuit that might stop it from happening at all. The Cash's girlfriend is filing more lawsuits. Will these at least have some merit? America First. You can't trust them. America First legal? They'll abandon you just when you need them. Stephen Miller, big fraud, it turns out. Trump fund. What's the problem with his weaponization fund from a statutory basis? Massachusetts legislative audit. Why do they oppose what the Massachusetts voters want? Well, shock, they don't want to be audited. And last but not least, Tom Fitton exposing the crooks at the in the crooks case, you might say.
Let me bring this one up. There was one more CommieTube chat. Can a county judge hide a gag order for Ben hidden in a TRO? Can they tell Ben not to talk without explicit orders taken away? No, they can gag him, but we would know that he's been gagged, I presume.
Yeah. It would still be illegal.
Well, they did it to Ben and they did it to Navarro. They did it to everybody. It's par for the course now. And then there was one more over on Rumble. I think there were two or just one. Barnes, have you had Michael Knoll makes a cigar? Have you had Michael Knoll's Mayflower cigar? Those are not his Mayflower cigars, but have you had the Mayflower cigar, Robert?
I don't know if I would trust a Michael Knoll cigar. God bless him. Just saying. Now, one of our great board members did send me the last made cigar in the history of Maine. So it came in a special thing and everything. It's really cool. I got it back at the home in Tennessee, which I won't be back to for several weeks. We have the World Cup starting this week. Of course, Iran apparently has to fly back and forth before each and every game, which I just think is stupid. I wasn't a fan of the exclusions in the Olympics and all that jazz, the exclusion of the Russians. We should separate out sports from politics and let teams just compete. I find it lame that they do this. But we got Canada, Mexico, U.S. all hosting games. We'll see if Canada, gets to the next round. The U.S. opening up here in L.A. against Paraguay. Brazil, Argentina, 48th biggest World Cup ever. If you want a deep dive, you can go to Sports Picks on Rumble, and for free, my brother and I, for about 2 hours, did a mega preview of the World Cup, and even some free picks thrown in if you want to see if you can make some cash.
Robert, let's do it. Well, now let's do the UFC one. I'm calling it now. One word, Robert. And if it doesn't happen, then there is no justice. Latches. Latches is when you've waited an unreasonable amount of time to take action. I think it was October, they announced that they're going to have this, epic 250th fight on the White House lawn. I covered how Sean Strickland has apparently been not disinvited, but just not cleared by Secret Service. Maybe just because of a few things. Maybe. So they set this up. It's the 250th on the White House lawn. Everybody's freaking out about the construction, or at least the temporary, whatever they have, the cranes. So it's been announced since October, November, December, January, February, March, April, May, 6 months. It's next week, and some activist organization.
This week?
Yeah, it's June 14th.
I think it's Thursday. I thought it was the 10th. I thought it was the 14th.
No, I thought it was the 14th, but now that you mention it, that would be a Sunday. I thought it was either way. It's coming. It's within a week. And some activist organization comes out and says that what was the basis? They didn't get congressional approval to make modifications to the White House lawn, which is a heritage site or something.
Oh, you're right. It is the 14th. Which
yes, that's a Sunday.
Wow, why are they trying to step on the World Cup? But I do know why they.
Why are they stepping on VivaBarnesLaw.locals.com?
Yeah, exactly.
Sunday night show.
Exactly.
Okay, so they've argued that it didn't follow proper procedure, that the lawn can't be modified without congressional approval. Even if it's all true, this has been known for 6 months. They're not coming in a week before and getting an injunction. Do you think there's a snowball's chance in hell that they don't get lashed out?
Yeah, because this is their argument. They thought that it was federally government run all the way through. And so the congressional authorization is that anything's a national landmark cannot be used for personal or for profit purposes. Mm-hmm. And it has to go through the strict permitted process. But if it's but they passed it, or they through their executive order, the National Park Service and others excluded America 250th anniversary events from the more rigorous permitting process normally required. But it's still required. Apparently, the broad assumption was, I'll be honest, this was my assumption, that this would be a public event, publicly available, publicly accessible, publicly viewable as part of a celebration of UFC connected to American patriotism. My first concern was when Strickland was apparently prohibited from going. Then I was like, hold on a second. You got one of the, particularly on the right, but just one of the better American UFC fighters.
He's the reigning champion. Back-to-back amazing fights and amazing victories.
Yeah. But I was like, he's not invited? I was like, well, hold on, what's going on here? And then it came out, and this is the basis of their suit, is that they didn't know this until last week, that this is all for profit, that they're selling VIP tickets for $1 million plus to hang out in the White House and then do the UFC event. That the UFC is charging people. You have to have a Paramount Plus subscription to even watch it. So this isn't a public event, which does make it illegal. The whole thing's illegal. I mean, we're going to hijack the 250th anniversary so Dana White can pocket a bunch of cash, so Larry Ellison can make even more money at Paramount, so Trump can make sure his donor pals get even richer. I mean, how much? I mean, this is bread and circuses without the bread and even the circus. I mean, So I was stunned when I read the suit, because I assumed, like you, like, what are they complaining about? They don't like the view. Okay, what they do? And I was like, hold on a second. It's all for private? They're basically saying, hey, you get to walk around the Lincoln from the tower, the Lincoln Memorial, and then from the come down, and you'll come down to the White House and out, and you'll be warming up. But you just need $1 million here, $1 million there, $1 million over here, $1 million over there. Only Trump could try to monetize the 250th anniversary for his personal profit of his donors. Trump is going to make money on this event himself because he's now an investor in UFC. So I think so what's their standing? Their standing is no latches because they didn't know about this until last week. They thought it was all for public and they thought it fit public permitting. They didn't know it didn't until last week. I'll be honest, nor did I. So I find that credible. Second, that they are park visitors, and as such, this interferes with their aesthetic interest in the park, for which these laws are set up in the first place, for which courts have previously recognized standing. So I'd say 50-50 whether they get a court comes in to enjoin it.
And throw in activist judges, even if you don't think even if you
like it. Why do they have to do this private? I mean, have Strickland there, have it public. America's 250th anniversary is for everybody. Don't monetize it to line your pockets. You're getting rich enough, Trump. Your kids are getting rich enough. When is enough for these people? For the love of God, it's driving me nuts.
I'll say that then maybe if that's the case, and that's going to be the consideration, they'll open it up, not charge, and have a big security.
Do random ordinary people can come in, and you can do the pre-screening, and do a lottery where ordinary everyday Americans, where people at the UFC fighter gyms throughout the country, or young fighters can come in. Do it in the patriotic American spirit. American Revolution wasn't built on a bunch of aristocrats sitting around with their powdered wigs eating their cakes and dressing up in dog masks like they'd like to do at Mar-a-Lago now by real Americans out in the grit. So this is an offense to our 250th anniversary. My golly, it annoys the crap out of me. And Strickland's a great fighter. Let him have there. Yeah, he doesn't like Israel killing kids, nor do most people in the world. That's no reason to exclude him. America's 250th anniversary doesn't need to be hijacked for Israel, too, for the love of the good Lord.
What's another last one here before we go over to vivabarneslaw.locals.com?
We got the SPLC superseding indictment. Oh. We got Cash's girlfriend suit. We got America First. Legal betrayal. We got Trump's weaponization fund, Massachusetts legislative audit, and the Crooks FOIA order. So you picked, and then we'll do the other five at the after party.
Let's do the America First here because you did tweet about it. Yeah, it could qualify as a vague post because I had to look up what you were referring to. Is this Red Hat? Is this related to Red Hat? Okay, so America First there's two organizations that sound virtually identical, and I know you make the distinction. Tell us what you...
No, I don't. Now they're both fraudster organizations. So it's easy. They're America First Legal, America First Policy, fraud organizations. That's what they are.
Which one is the one...
America First Policy is the one that staffed the whole White House. America First Legal was the one that was doing good work, founded by Stephen Miller.
Okay, so America First Legal Stephen Miller he founded it. Okay, fine. And they were involved in the Red Hat case, which was white discrimination by basically DEI kicking out whitey. And you were involved in that as well. So you got to flesh out the context for your vague post so that everybody understands what you're talking about.
I wonder why Chris Kraft gave exactly $7.40. It probably has some meaning, but I'm not sure what it is. So America First Legal started doing good work during the Biden administration of these racially discriminatory grant policies, immigration abuse policies, H-1B visa abuse policies, and racially discriminatory employment policies, including discriminating against people for racial reasons, religious reasons, gender reasons, basically, and for COVID-related reasons. So if you were straight, white, male, of the wrong age bracket, the wrong religious beliefs, who questioned the COVID vaccine, you were targeted for discrimination at every level of employment, promotion, transfer, the keeping your job. And one of the big abusers of this was Red Hat, connected to IBM. America First Legal went around soliciting these cases, wanting to be involved in these cases, demanding to take over these cases, making all kinds of promises to people, which I was fine with, by the way. I was fine whatever role they wanted to play. So we get into this case, get dragged it through federal court gets it transferred to arbitration, disagree with that, but that's how it goes. So now we're in the nitty gritty of arbitration where the real work goes. And what does America First Legal do? Suddenly abandon the case entirely. And they're doing this in a bunch of other cases. And what's instead, in part, that's because Stephen Miller's now in the White House and his objective is to be Israel first, because Stephen Miller, like Harmeet Dillon, cares more about Israel's justice and Israel's civil rights and Israel's cause civil rights than they do Americans' cause civil rights, whether it's race, religion, gender, or anything else. And they've proven that on a regular basis, unfortunately. And Stephen Miller's busy running around when he's not lying about Thomas Massie, is telling everybody that we really need that FISA Surveillance Act passed so we can spy on everybody, because otherwise it's those lefty courts in D.C. lying about the fact the FISA court is picked by Republican appointee that Stephen Miller cheered on, John Roberts, and most of them are Republican other judges. So he's just lying to people about why they need to illegally spy on everybody without a warrant. There is no warrant requirement if you're spying on foreigners anyway. There's only a warrant requirement if you're spying on Americans, which Miller is lying about. But America First Legal has become a complete joke, complete fraud. If you're out there, you can't depend on them. You can't rely on them. They'll drop you on them in a moment, the moment it's convenient, the moment it's useful for them. They no longer care about these political issues. They are driven by a different set of donors now. And unfortunately, they've become as traitorous as so many others in this administration have become towards a large part of the voter base that put them there.
All right. We're going to go. Well, we're going to actually do one more before we raid. Robert, what are you doing this weekend? Are you going to have bourbons with Barnes's from wherever you are?
Oh, so tomorrow will be What Are the Odds, 6 p.m. Eastern Time with Richard Barris. We're going to break down the House of Representatives and explain some math because some people are struggling with this math. That reminded me of the other topic for the after party, what's going on with the California elections, but we'll detail that too. Then throughout the week, I think I have interviews with Dialogue Works, Mario Knopfel, let's see, Judge Napolitano, and I think a couple of others. And then we'll also have bourbons Tuesday, Wednesday, and Thursday. We'll start to try to get some good candidates from different places that we'll try to get up and going up this week too.
All right, we're going to raid into, it's called whatever, debate. She accused him of sexism. Guys, it'll be a distraction if you don't want that. Let me just see if there's nothing else. Now, we're going to go raid into them. Stick around with us. If we happen to crash, people, we're going to kick up the stream immediately. But we're not going to crash because Rumble has fixed the, what did I just do here? /raid. I'm going to be on with Hotep Jesus, Robert, on Tuesday. So I guess it's going to be racially charged because everybody, there seems to be a racial divide on the Karmelo Anthony prosecution, one which I don't subscribe to, but I had a back and forth with him yesterday and Maj Touré. Do you know who Maj Touré is?
Yeah, vaguely from Twitter.
I think it's some. I don't know of his music. I'm fairly certain it's hip hop. So it'll be interesting. We're gonna have a discussion Tuesday, 5:00. I'll be live throughout the week. Let's go kick the party on over to vivabarneslaw.locals.com.
Yeah, we'll cover the Southern Poverty Law Center superseding indictment. Cash's girlfriend Alexis Wilkins sues MSN now. She might win this one. The Trump weaponization fund. What's the problem with it statutorily? Massachusetts legislative audit. Tom Fitton getting FOIA on the Crooks assassination attempt of President Trump, and what's going on in California's elections. Is it fraud, or is it lazy partisan Democrats voting late, or is it some combination of all of the above?
It's fraud. That's what my own personal opinion. And we're going to get to all of the tipped questions because I think this is the way the community likes it. We're going to have a dedicated reading all the tipped questions there. So go raid out, and if you're not going to do it, stay here. Confirm raid, and then we're going to go here. Viva raid booyah. And now we're going to go update to Rumble Premium and vivabarneslaw.locals.com. Let me just make sure I didn't miss anything here. CommieTube, we're good. Tipped questions were all up to date on Rumble. We're going to get to the tips on Locals, and now we are updating. Do not kill this stream. Update.